All right, good morning, everyone. Today is October 24th, 2018, and this is a regular meeting of the members of the State Liquor Authority. Present today are Chairman Bradley, Commissioner Ford, Commissioner Fan, General Counsel Riano, Deputy Commissioner of Licensing Held, and myself, Secretary Donahue. The next meetings of the authority, the regular meetings, will be on November 6th and November 20th. Those are both Tuesdays. And then December 5th and December 19th. Those are Wednesdays. And as you have a cell phone, please put it on silent. And if you have to take a call, please take it outside. As your item is called, please approach the podium and speak into the microphone so that everything gets recorded. We're going to call items first. Actually, we're going to do a public hearing on some proposed regulations here in New York first, and then move to Buffalo, then Albany, and then back here to New York to finish the calendar. Chairman, do you have anything else to start the meeting with? Okay, so we're going to start off. The first item is 2079. This is a hearing on proposed rules regarding bottle club licensees. Just note that the hearing will start today. However, the public comment period will be open for 5 days after today. And then once the members get to review the comments, the matter will be placed back on the calendar if the members decide not to adopt the rules as is or make any changes. I think Mr. Brookman wants to be heard.
Okay.
Thank you, Mr. Donahue. Good morning, Chairman Bradley, Commissioners Ford and Fan. Max Bookman, on behalf of the New York City Hospitality Alliance. Do you have our written comments? I have copies if you'd like. You have it very well. The New York City Hospitality Alliance is a not-for-profit industry trade association representing thousands of eating and drinking establishments throughout the 5 boroughs. And we're here today in strong support of the proposed regulations that would modernize some very antiquated rules concerning the bottle club license category. We'd like to note that under the leadership of Governor Cuomo and Chairman Bradley, the authority has firmly established New York State as a leader in modernizing and liberalizing antiquated alcohol control laws, and we believe that the proposed rules regarding bottle clubs is an excellent example of applying innovative new thinking to an old license category. The authority's rules, which is, as far as I could tell, have been around since at least the 1970s, really straitjacket the bottle club license category beyond what the statute provides. When they were enacted, they were for a type of hospitality concept that has essentially died out in New York City, where people bring their own bottles of liquor to an establishment and consume them on premises, but there's no alcohol being provided by the establishment. The proposed rules would modernize several of these provisions. What's most important to our association is that the proposed rules would allow a licensed bottle club to give alcohol to its customers, so buy it from a distributor and give it to its customer. And the context in which this is important is we are seeing in the retail sector a great deal of innovation, and with this old ABC law and some of the old rules, it's a lot of times it's like fitting a square peg into a round hole. And so, for example, there are many high-end retail establishments, high-end jewelry establishments and clothing establishments that would like to be able to offer a glass of champagne or a glass of scotch to their customers as part of the shopping experience. Right now, under current rules, there really is no category that fits that, and we believe that the modernized regulations would allow these types of businesses to apply for a bottle club license to allow them to legally give a glass of champagne or alcohol to their customers to complement their shopping experience. And frankly, that's something that I believe is being done now. This would bring it into the scope of, out of the shadows and into the daylight. So we very much support it, and we hope the rules will be passed as written.
Thank you.
Thank you.
Thank you. Does anybody else wish to be heard on the proposed regulations? All right, so we're going to conclude the comment portion, and as I said, the written comments will still be accepted up to 5 days after this date. All right, so we'll move on to the next item, which is in Buffalo. It's 2174 J.P. Coughlin, Inc.
Good morning, Chairman Bradley, Commissioners Ford, and Commissioner Fan. Janelle McCarthy of the Noor Group on behalf of the licensee J.P. Coughlin, Inc., and with me I have Joe Coughlin, who is the president of the corporation.
Could you hold
We're
on
here
one
to-
second? Could you hold on? What number is this, Tom?
2174.
That wasn't on the list.
Okay, go ahead.
Good morning again. Apologies for that.
No, my fault.
We're here this morning with regard to a plea that's been submitted to the board. We've spoken with Lisa Ogden, and we've pled no contest and proposed a plea, a penalty of $7,500 for the pending violation. We would ask for the authority to consider a further reduction in light of the facts of this licensee's history. The licensee has been licensed without any issue for 32 years. This is a long-time dedicated operator. What happened in this situation was Mr. Coughlin wanted to, or was approached by a proposed tenant who wanted to operate the beverage, or I'm sorry, the food portion of the establishment. And that tenant sought the services of an attorney in Fredonia, who then sought the services of a what we call a SLA consultant, who is not an attorney. They prepared paperwork, they prepared a concessionaire's agreement, and then they were told by the consultant that they could commence operations because the application was, quote, pending. Obviously, we all know that is not correct. And I understand that ignorance of the law is no defense, but again, this is a, licensee with a 32-year clean track record, and we would ask that the authority take that into consideration. As soon as we found out that this was not proper and a violation was issued, they then engaged my services to assist them in cleaning up their license and getting them into compliance. I can now say that we have the class change application pending, which would change the licensee from a full-on restaurant to a tavern. They have the appropriate food prep area and menu to satisfy the food requirements, and the tenant's space is no longer connected, and actually they're no longer operating. And so they have come into compliance. The conditions will be satisfied shortly. We're just waiting for some documentation from the Department of State. And we would just simply ask that the board, again, take into consideration the licensee's clean history of 32 years when they consider the penalty to assess here.
I think that was already taken into consideration, to be honest with you, because normally we probably would be taking the license in this situation. So I'm going to stick with the 7,500.
Commissioner Fan?
I would agree with the chairman. I was actually going to go up, but given your presence today, and that the business is now in compliance, 7,500.
Commissioner Ford?
Based on your history, I would have voted to reduce it a little bit, but it looks like it's going to be 7,500.
Thank you for your consideration.
Thanks.
You're welcome.
Michelle, I have nothing else in Buffalo?
There's no other matters in Buffalo.
All right, we're going to move to Albany then. The first items there are 2090, 91, 92, and 93. This is Terry F. Carpenter, Jr.
Thank you for the opportunity to speak here today. I've prepared a statement that I would like to read, and then I'll be glad to answer any questions. First, I would like to address the reason that my license was denied. On the personal questionnaire, I made a mistake. I answered no to a question that should have been answered yes. There was never an intent to deceive the liquor authority. I was well aware that my pending case would come up during a background check when my fingerprints were submitted. I understand the opportunity to obtain a liquor license and own my own business is a big deal. For me, it could turn my life around. In a rush to get everything together as fast as I possibly could, I made an honest mistake. It was a careless mistake and one that I would like to correct. In July, I began working on the liquor license and fixing up the bar. Over the course of the past 3 months, my business outlook has been positive. Everything was submitted to the liquor authority for approval and the bar was coming together. I was excited when I received approval for the temporary permit, only to find out a short time later that my license was denied. On the business side, I have been working on organizing my office, training employees, and putting together a market plan. I have been training employees for 6 weeks, and I have sold 3 advertising packages to local businesses based on my marketing plan. I am prepared to open and operate with integrity and to become a contributing member of our community. On the community side, I organized a fundraiser in August to help needy children with backpacks and school supplies. I am proud to say that we were able to donate backpacks that were filled with necessary school supplies like pens, pencils, and papers. On our next fundraiser, I will help the less fortunate around the holidays with a food drive. Our goal is to donate 50 cases of canned goods to the Salvation Army. In the past, I have made many mistakes that I regret. With this opportunity presented itself, it gave me the first opportunity to make something of myself and start being a contributing member of the community. I'm asking you to be a part of turning my life around by forgiving my honest mistake and giving me an opportunity to succeed. Now I'd like to answer any questions that you have for me. Thank you.
Is the case over now?
Yes.
And it ended up being a misdemeanor?
Yes.
You guys have any questions?
No.
No.
You have any? All right.
You already vote?
Yep.
Commissioner Fan? This would just be to decide whether or not you're going to reconsider and
to
return to
licensing.
licensing.
Okay. I'll send it back to license.
I'll send it back to licensing as well.
I will as well. Just remember that everything, you got to read every question because
I
a
know.
mistake
yeah.
like this, once you're licensed, could cost you your license. So,
Yeah, I know. I realize that now. I was just, at the time, I was just trying to get everything done and just trying to get the bar put together. I put literally so many hours into the bar already, and I just rushed. Literally, when I was filling out the application, I just rushed.
all right, well, we're going to send it back to licensing and you'll hear from them shortly. They'll continue to review it.
Okay, thank you.
All right, the next item in Albany, 2172, why not? It's a request for reconsideration.
Good morning. Lost my pen.
There is opposition present for this.
Okay, can we hear?
Matthew Wagner on behalf of Why Not, the applicant. This is Paul Cook to my left. Good morning. And Mr. Anthony Cove. We're here on reconsideration of the decision that was issued in September by the board on our initial application. We have asked for reconsideration based upon the extensive resources that have been invested by Mr. Cook. He has moved from Brooklyn with his life savings to pursue his lifelong dream of owning his own business, in this case a unique boutique wine store aptly named Why Not. Mr. Cook's business plan is unique from any other business plan in the area, and his skill set as a certified sommelier, a accreditation held by less than 2,000 people worldwide, places him in a very unique position to deliver on that and to deliver on the public policy set forth in Section 2 of the New York State Alcohol Beverage Control Law. In particular, promoting temperance through educating his customers, supporting economic job growth and development, and the state's alcohol and beverage production industry, because Mr. Cook's business plan is going to be focused on serving New York State wineries, which he has been in extensive communications with, and he's proposing to dedicate 25% of the floor space in his shop to those wineries. That will also help promote tourism and recreation in those industries where the wineries are located, and promote the conservation and enhancement of the agricultural lands upon which they operate. Hitting almost every part of Section 2. The board noted that in its denial that there are 4 package stores within 3.3 miles of the applicant's location. As the board is well aware, the distance restrictions that were in place prior to the SLA statute being amended were replaced in part because of the Morelands Commission's finding that it was designed to prevent liquor stores from locating in clusters. And admittedly, there will be a small cluster of liquor stores. This Why Not premises will add to the small cluster, but will not, based upon the business plan and Mr. Cook's skill set, detract, but instead add to both the public convenience and public advantage as we've outlined in our submission for reconsideration. Why Not, as we stated before, is located next to the largest grocery store in the area with no licensing nearby, next to the nearby Price Chopper grocery store.
Isn't there a license a quarter of a mile away?
There's a licensee a quarter mile away from the proposed premises and
So
Price
that's
Chopper,
not
but
near, that's not nearby?
it's not within walking distance, Mr. Chair.
But you're in Troy.
I don't know who this is to my right. I believe he's from Lighthouse, but I would just appreciate a little bit of decorum here while I'm presenting.
Okay.
The reality is that the Hannaford grocery store, located directly across the street from the proposed premises, has a crosswalk as outlined in Exhibits A and B to our application. It has a parking lot dedicated specifically for customers to use and a crosswalk that will allow customers shopping at the Hannaford supermarket to walk directly to the premises, adding to the public convenience. The other stores were not located anywhere near in proximity to those grocery stores. To these two grocery stores.
Correct me if I'm wrong, because my office is only a couple miles from Troy,
Sure.
but pretty much everybody in Troy drives. So a quarter mile, we're talking about less than a minute.
That is likely to be the case, but when people are shopping for their groceries and they can make 2 stops and 1 stop instead of 2, that is a public convenience. That would be something that I think we can all agree would be more convenient than not. And that's something that the board should consider in this application.
Do you have permission, from Hannaford to allow for your customers to park in their lot and walk across the street?
Well, we know based upon conversations that we've had with both the landlord and the prior business owner that was located in that location that they did that without having specific permission from Hannaford. And if people are shopping at Hannaford for groceries, I don't see a reason why Hannaford would police that use.
All right, do you have any evidence that the other 4 stores within 3.5 miles away are not selling New York brands?
We have evidence that our proposed 25% is more than any other proposed licensee has currently.
So they are selling New York wines?
That's our understanding.
Okay.
I don't know how much they're selling. I can tell you that our review of those stores demonstrates that they are a more traditional liquor store than a wine store. They are selling liquor through advertisements in their windows and large cardboard proposed or advertisements within the stores, highlighting the standard liquor that's being sold in liquor stores, whereas the business plan proposed by Mr. Cook, the store is named Why Not for a reason.
So why not get a wine license?
Well,
Because you want to sell the liquor.
we certainly do want to sell the liquor, but the liquor again will be a more sophisticated process. Mr. Cook, when he was trained as a sommelier, is not just trained to talk about wine. He's trained in service. He's trained to talk about liquor. He's trained to pair those 2 unique products with people's selections for their food. This is that's what he's attempting to do here, and I don't believe that the considerations that were previously before the board highlighted that. I also think the board perhaps overlooked the changes that have taken place in Troy and in the area, including most recently the Troy City Plan, which was approved since prior applications were denied. One of the issues that we've highlighted in the application for reconsideration is the extensive amount of investment that's occurred within the last year and a half in the city of Troy, including the significant investment in residential apartments. And while we admit that the population of Troy has remained somewhat stagnant, the demographics have not, and neither has the economic activity in Troy, which continues to boom. And as the chair well knows, is going to continue to do so. A few of the other things that we think are worth consideration here, Mr. Cook is going to open a store that is small in a non-intimidating environment, focused on service and focused on educating his customers. He's also working towards utilizing his New York contacts to bring in unique experiences for people looking to drink wines outside of California Reds. And he's trying to do what you could call a startup pipeline for wineries in his location, which is demonstrated by his commitment to put 25% of his store square footage towards New York products. And as one of the board members, I believe it was Ms. Fan, noted, Mr. Cook is an incredibly well-situated applicant. He's well qualified. He's worked in the restaurant industry. He's as a bartender and waiter. He's worked as a sommelier. He's worked in a liquor store. He is prepared to add to the fabric, the ever-changing and growing fabric of the city of Troy with this store. And the fact that there's nearby locations alone is not enough to justify the denial of his application. And we would genuinely beg the board here to consider everything that he has done up until this point to put him in a position to execute on something that is a lifelong dream of his, to own his own business and to capitalize on his years of training and experience by bringing something new and different to the area. This is not going to be your run-of-the-mill liquor store, and that's indicative in the name of itself.
All right, thank you. You ready to vote?
Yes.
We have, you want to hear from the opposition first?
No. I mean, now we're going to vote for whether we reconsider or not. Then if we do, we'll
Okay.
hear from the opposition.
Commissioner Fan?
I appreciate the effort. I really don't see any change in circumstance since we voted on this last time. So I'll vote no.
Commissioner Ford?
I'm going to vote no to reconsider as well. I don't really see any change to anything from what we decided before.
I'm also going to vote no. I think that the basis that we denied it last time, I don't see any new information that would require me to change that vote. Thank you.
All right. The next item I have in Albany is 2088, 35 Vassar Road Snack Shop, Inc.
Good morning, Commissioners Fannin, Ford, and Chairman Bradley. Mayor Fakuri for the applicant.
What's your name?
Mayor Fakuri. I'm an attorney for the licensee.
Okay, I'll grant reconsideration just to accept the 3,500.
I agree.
Same here.
Thank you.
I don't have any other items signed in Albany?
No.
All right, so we're done with Albany. We're going to move to New York. First item in New York is 2167 Croton Falls Gas Mart, Inc.
Did you lose your channel? Nothing. I thought I had a pen, but I guess I don't.
Go ahead.
Morning.
Use mine?
My name is James
I'll get one.
Burchetta, Burchetta & Associates. I represent Croton Falls Gas Mart. We're asking for a reconsideration of your previous decision. My client was represented by a lawyer who failed to appear and present any evidence to refute this charge. And
Well, that wasn't actually accurate. It was, they defaulted on the pleading. So nobody responded to the pleading.
exactly, he had spoken with and retained a lawyer to handle that, and apparently he did nothing. And the circumstance is that
Oh, I
on the-
see. Okay, I know why.
Yeah.
Yeah, yeah, you don't need to go on.
Okay.
We're, we're going to send that back to the council's office.
Okay, thank you.
Wait, they're going to have to vote, but
Yes, back to council, sir.
Yeah.
I appreciate it, thank you.
Mr. Donahue, I don't need to say this, do I?
No. All right, we're just going to take one item out of order. The next one's going to be 2077, which is Classic Man LLC.
Good morning, members of the authority.
Hang on a second.
Is there anybody else who wants to be heard on this? Why don't you come up over here?
Okay.
Good morning, members of the authority. Michael James, appearing for Classic Man LLC. Appearing with me is Isaiah Michael, one of the principals of the applicant. I will yield the floor to the opposition, as customary for them to.
well, so I don't even know if we need to hear from the opposition, because my initial thought is that this isn't legal under the statute, correct?
64A, 6A.
And what, can you just explain to them why it's not?
Primary business rule. I mean, the primary business would have to be the service of food and alcohol, which doesn't seem to be what the business model is here.
So he's essentially starting two services in one place, just like 3 Espresso Bar that's on Avenue A and Blind Bar that's on East 10th Street. These concepts have been in the neighborhood, and it's popping up all over the neighborhood, so that's what he's.
I can't hear you. Can you speak into the microphone? I think what he's saying is that the primary business that your application indicates for this business is that it's a barber shop. The statute requires that the primary business be for food and drink if you're going to get this license, and that clearly is not the case with your business. So we couldn't, even if, regardless of the opposition, we couldn't grant it anyway.
Okay.
Now, there may be other ways to go about doing this under the law. I'm not here to give you that advice, but this isn't the way to do it, correct?
Yeah, as far as I can tell.
Okay, can I have a conversation with the applicant?
I would go downstairs to talk to licensing.
I mean, we're going to deny this because we can't grant it, so your best bet is to try to talk to someone in licensing.
So the method of operation had to be changed because of the basement, and there is.
No, the statute that you've applied under requires that the business be focused only on food and drink. There can be other things going on, but your main focus of your business is clearly to be a barber shop that wants to serve drinks.
So that was the focus of it. And now he's changing the operation to add on that service as well. So it's 2 services. The method of operation had to change during the application process.
Yeah, but we saw the diagrams. It's a barber shop.
Right.
It's not a bar.
But he had a whole full kitchen in the basement.
Well,
But we had to take it off. And that's the issue. And I understand, I did have notes about a full method of operation change that aren't reflected in the application as of right now. But I understand your position. I do.
Talk to the guy behind you who knows about Bottle Club.
No, that's.
That might be the way to go here?
I spoke to him about that just 10 minutes ago.
Okay.
I think that is the way to go.
We'll see you again.
All right, thank you. Sorry you all had to come down here, but
Next item is 2104, BMNR Inc.
Good morning, Stacy Weiss. I represent BMNR Inc. This is the principal, Robert Hayes, and I'm here to answer any questions regarding the licensing of 750 North Avenue, New Rochelle.
well, so I have a lot of questions. What is he going to do different since this place was a huge issue, which I believe canceled the license in November of last year,
Yes.
and he was there for all of the events that occurred?
Well, yes, he was.
And when I say events that occurred, we're talking about sales to minors, max occupancy, multiple sales to minors.
Yes.
And multiple violations of occupancy levels.
Yeah, well, he did work there for 7 years. As a matter of fact, he did witness those things, and he was there since, he started there from time he was in high school. As a matter of fact, he lived in New Rochelle since he was 10. He had summer job-
I want to know what he's going to do differently, and why we should believe that he's not going to allow the same thing to happen. Some of these sales to minors, the minors were 16 years old.
Yes, okay.
And he was general manager.
Okay, well, he's going to have a point of sale, he's going to have a scanner, he's going to have a tally canter, he's going to have handheld scanners, he's going to have tally canter. Each person is going to have a scanner. Security is going to have tally counters at the
Well, so
door.
I don't understand the scanning part.
Okay.
You're going to tell me now that he's decided he's going to check IDs? Because
No, no.
you can't tell me a 16-year-old came in with a fake ID.
Well, he wasn't in charge at the time. What happened was he worked there. He was mostly in the back of the house when he was working there.
It says he was a bartender.
At times he was a bartender, but that wasn't his main job when he was there. His main job was at the back of the house. He did try to make changes when he did make suggestions to the owner, and he actually bought his own ID scanner. He went to the owner, made suggestions to the owner. When the owner would not listen to him, he bought his own ID scanner out of his own money. He tried to make changes there. He told the owner to get a tally counter that would make some changes to the place, would improve it, to reduce the overcrowding. And he eventually, he was able to get the place.
So you're telling me he was the general manager,
that-
and the owner of the place required him to fill it to past capacity on not one occasion, but a half a dozen occasions?
As a matter of fact, that is an error. He was not the general man, he was never the general manager. That's an error. He was one of four assistant managers, and he did try to make changes. The owner would not listen to him. Now that he is the owner, he is going to make all the changes he wanted to make in the beginning. He's going to have scanners, he's going to have the security, he's going to never have the place more than 90% capacity. He's going to have security cameras inside, outside, and he's going to make it a family restaurant. It's not going to be a college atmosphere bar at all, no live music, no DJs, no dancing, no karaoke.
It appears to me it was a high school bar before, not a college.
Well, it's not going to be anything like that now. It's going to be strictly family-oriented. He's going to have, like I said, no live music, background music only. It's going to be, it's menu-focused. He has a big menu now. It's going to be really very family-oriented. And he has letters from the community he has letters from the community to prove that. He has a letter from the mayor. He has a letter from police officers. He's the president of the New Rochelle Chamber of Commerce. I mean, what kind of a example would he set? He's the president of the Chamber of Commerce. He has, like I said, he doesn't want to have, he's not going to be a problem to the police or the community. Like I said, he's the president of the Chamber of Commerce. I mean, he's not going to be a problem. He has to set an example.
Can we talk to Mr. Hayes for a second, please?
I wish you would.
Yes.
Please do. He's going to explain to you.
So, Mr. Hayes, tell me what were you doing there? What was your gig?
My main role was, I started off there when I was in high school. I started off as a dishwasher, kitchen prep and whatnot, and over the years I moved up different roles. But my main focus has been kitchen. I started the delivery system we have now in place. I created the current menus. We were working on catering. I trained the new cooks, the new prep cooks, and that's my main focus. Because I've been cooking since I was a kid, and that's and I know I'm aware of what happened with the former owner. My main plans, though, would include like the Stacy, that's why I said ID scanners, licensed security guards. I'm not trying to have a bar. I want a local tavern, family restaurant establishment. I saw the headaches that came with what the former owner did. I did not agree with that. Like I said, as being president of the Chamber of Commerce, I'm trying to set an example. I have to lead by example. There's nothing, I know I don't want to run a crappy business model because I'm supposed to lead by example, and that's very embarrassing.
Where is the former owner?
He left. He works now. He got a job for FEMA. He was a firefighter.
FEMA.
Mm-hmm.
I feel safe.
How many security guards?
Oh. Our busiest nights were Friday and Saturday nights, and to help control occupancy and help change the image of the place, I was going to put on 2 on Friday, 2 on Saturday, to just double ensure the IDs and to ensure that we reach our 90% occupancy to never go over the 100% occupancy again.
What are you planning your hours to be?
Personally,
What are your hours?
operation?
Yes.
From 11 a.m. to 2 a.m. And there's been a need for food at night because that's one of the main things I changed since May is we started delivery and keeping our kitchen open to 2 a.m. There's been a huge increase in deliveries to the surrounding community, including the dorms. And also, New Rochelle is going through an economic boom. There are several skyscrapers going up, and there's just going to be more need for food and late night delivery and restaurants.
All right.
And in addition to everything I was mentioned before, so we're going to have a point-of-sale scanner at the door on Friday and Saturdays with the guards, but on top of that, my staff, who I've gotten everybody certified in 8 tips and taps. I am Serve Safe certified for the food and health. Oh, apologize. The tally counters, digital tally counters, the security cameras. I submitted a procedure guide that all staff will read and follow to ensure that the guidelines are followed that I set up to ensure that all customers under the age of 40 will be ID'd, scanned, and used and inspected through our training through ATAPS and TIPS program.
How long have you been open without the alcohol?
Since May. And then on Friday, Saturday nights, to help to fulfill my goal, at 9 p.m. on, there will be no one under the age of 22 allowed in. They'll only be allowed for takeout and delivery. No sitting. Let's see, all the staff who are looking forward to working, I said have been certified and trained.
All future staff will be trained.
Yes, so all 8 tips turned. Anything else?
Yeah, I'm good.
Ready to vote?
Yeah.
Yes.
Commissioner Fan?
Can you just tell you one more thing about all the,
Sure.
tell about all
I am, I said, I'm part of the New Rochelle community. I'm heavily involved in the community. I do a lot of volunteer work with the CYOB basketball program, the New Rochelle Public Library. I actually organize a Thanksgiving Day parade every year. I help sponsor the National Night Out, Coffee with a Cop. I help sponsor New Rochelle Street Fair, the Art Fest here in New Rochelle, Kite Day in New Rochelle. I support the New Rochelle and sponsor one supporters of the New Rochelle High School varsity.
I read your 13 letters of recommendation. I think I got it.
Okay. Sorry about that.
Thank you. No, I appreciate the effort. I appreciate your dedication to your community.
And also,
I
it also wasn't the,
I get it.
Twice,
You don't
twice.
have to.
You're voting.
I think I'll be comfortable with midnight close, 2 licensed security guards, Friday, Saturday. No live music, no DJ, family-focused restaurant.
Commissioner Fan, just for clarification, is that could be 2 a.m., everything is closed, or 2 a.m. stop
12,
service?
she said.
At 12 o'clock, every night.
She said 12.
I was just making sure there was alcohol service or the restaurant.
Oh, right.
Just alcohol service.
Commissioner Ford?
Based on letters of recommendation you got from the mayor, city manager, bless you, former city council member, Westchester County legislator, director of the New Rochelle Chamber of Commerce, campus safety from Iona College, detective from New Rochelle Police Department. I'm going to give them credit for knowing their city better than I ever will. So if they're willing to support you, so will I, under the conditions that Commissioner Fan has stated. I'd be willing to go to 1 a.m. on weekends, though, for you. And then you can come back in a year. If everything is well, then, you know, we can reconsider it from there.
And I'm going to vote to deny. So if you want to work on the hours, go ahead.
I'm on midnight.
Then midnight it is.
Is that just for the alcohol, midnight?
Just the
Yes,
alcohol,
just the
yes.
alcohol.
You can say open till,
Yes.
Okay,
okay, all right, thank you very much.
thank you.
Next item is 2098, Ultraviolet Enterprises LTD.
Good morning, Mr. Chairman, Commissioners. Max Bookman, Pizetsky and Bookman on behalf of Ultraviolet Enterprises. To my right is Joshua Cobrin. He and his wife, Lily Karanova, are the owners of this restaurant in Long Island. This was a hearing. The reason we went to the hearing was for charge number 2. The charge number 2 didn't exist. We probably would have settled this. Charge number 2 said that the principal acted abusively and improperly with police officers. That wasn't true. We took it to a hearing. After hearing the testimony, counsel's office decided that there wasn't enough evidence to support that charge, and they withdrew it, which made us feel vindicated. Yet, nevertheless, we were still in the hearing for the other 2 charges, which both amount to a first-time books and records violation. We're not going to take issue with ALJ Harvey's analysis. We would just hope for a penalty commensurate with the first-time books and records violation.
I'm at 3,000.
Commissioner Ford?
I'll go with 3,000 as well.
3,000.
Thank you very
Thanks.
much. Thank you.
Next item is 2084, JK's Westchester Restaurant Corp.
Good morning, Chairman Bradley, Commissioner Ford, Commissioner Fan, Council Riano, Bruno Joffrey for the licensee. This was resolved with a $3,500 civil penalty on a disorderly premise.
Wait, what are we on? 28? This is a change in method of
Yeah,
operation.
but initially, as part of the deal with the $3,500 civil penalty, we were required to file for a change of method of operation. So,
Well, you weren't required to. If you wanted to operate in the way he was operating, that would be the proper way to do it, but it doesn't mean he's going to get it.
I understand. I think as part, what I meant was as part of the disposition, we filed this. There was,
Okay.
So we did file it. My understanding that there was really no, other than the disorderly premise that I just spoke about, no other adverse history prior to that. This was a situation where the current licensee
That's
had.
actually not accurate.
Oh, I'm unaware of that then. I was just.
That's, I mean, there's not a lot, but, and it's from 2011 and 2006, but he does have adverse history, and 2013.
Okay, do we know when the current licensee filed for the corporate change application, when he became, Mr. Crespo? Because it's my understanding that he was unaware of the hours being a situation where he wasn't the original applicant, so he was unaware that it was an 11
There was a
PM
corporate
closing.
change in March of 2006.
Okay, so.
I'm assuming that's the one you're talking
Yes,
about.
yes, thank you, Chairman. So, in terms of the increased hours, the main purpose of it was because he, when he purchased the business, was unaware that they were locked into a 11 PM closing. Now he's trying to rectify that, and that's before you. We did notify the city of Peekskill. I'm not sure if they sent anything in terms of
They did not.
their position, but.
So
we
he
did-
now wants to be open till 4 AM every night?
Yes, which, by statute.
Well, that's the max. It doesn't mean that you get it. How long, so he's owned this place since 2006?
Yes.
I find it hard to believe that you didn't know, and somehow you're framing it as he was locked into 11 p.m. I mean,
Well, the
this
original,
is more than 10 years.
Yes. He was unaware.
And
I
your
mean,
client is not here, so
he
it's
couldn't
hard
appear.
to.
He had to actually travel to go see a relative out of the state.
Well, if this has been going on for 12 years.
Again, this isn't the first application where this has happened. I know there's a
It
lot of
just
people-
doesn't seem like playing by the rules is a priority here, so.
He's, at this point, he's trying to rectify what,
All right, you have any? We know where she is. Do you have any?
No.
Ready to vote then?
Yeah.
Go ahead.
I can hold it over until your client comes on the 6th. Or I'm going to deny it.
That's exactly where I am.
Okay.
when would it be?
The 6th. Can I use your pen for a second?
It's a Tuesday?
Yep, it's election day.
Thank you.
Wait, are you available, or
I can't appear on the 6th. I have a family obligation.
We can do it. What's the next one, Tom?
20th?
20th?
The 20th is fine.
And he's going to be, your client will be here.
Yes. I'll make sure.
It's a nice pen.
Thank you.
Only cost me $23,000.
Thank you.
Next item,
Thanks.
2129, Dick's Dog Corp.
What happened to 2085?
I'm sorry, hold on for a second. Which happened, which number?
All right, we can do his. You just had another one up there.
2129.
Morning, Commissioners. Martin Mailer of Mailer Buscemi. This is an application for a new on-premises liquor license. The reason it's here is because the previous licensee had some difficulty within the premises. These are the two principals. They have nothing to do with the previous licensee other than buying the establishment and getting an assignment of the lease. I'd like to hand something up. I realize it's late, but it was just given to me by my client. These are two character references as to Mr. English's background. He is a former auxiliary police officer, and these are two acquaintances of his who were former police officers that attest to his credibility.
How are you guys related?
They're not.
You're friends, but you're on the licensing. Okay.
But Mr.
So my biggest issue is that they hired the manager from the old place.
No, they didn't. No, they didn't.
That's what I have, the information I have. Do you have a manager?
Yes,
And what's his name?
it's a female.
Jasmine, correct?
And
Yeah.
she worked at the place previously, didn't she?
For a short time, from what I understand, she was a bartender there.
Yeah.
Oh, I'm sorry. Yes, but if,
Well,
if
so
I
that's
may-
my issue, because, all right, they're new, and they're gonna do what they say they're gonna do, and I believe them, but why would I believe that she's gonna?
Well, if you want a different manager, I thought that because they don't have any formal experience running a premises.
Oh, I'd like a manager, I just don't like, I think the manager that caused, or at least was there for the problems is an issue.
If I may, although we'll get you a new manager, that's not the issue. If you want to make it subject to a different manager, that's fine too. But it's my understanding that the previous premises, most of their problems relate to someone who was an undisclosed, who kept coming into the premises, who apparently had an affiliation. But that was the...
Well, no, they had a host of violations.
Yeah.
Disorderly premises,
Oh, well,
Books and records, occupancy.
failure to supervise,
Oh, well-
no workman's comp, I mean, the employment of a felon, which I think is what you're referring to, non-bona fide.
If it means getting a different manager, please, by all means, that would be
Well,
no
so
problem.
what's going to be different, because they have the same method of operation as the place we shut?
Well, first of all, they're going to run it in a responsible manner, and second of all, as I understood it, the premises itself was, although I heard what you just said about disorder, this gentleman has a law enforcement background. All he wants to do is run an orderly premises, and doesn't want what occurred in the past to continue. And we'll be hands-on. We'll be there at all times to ensure that this doesn't occur. I mean, Obviously, if there is a problem, the counsel's office will bring the charge, and it'll be before you, and your memory is very good in terms of, warning.
Yeah, but then I won't see the charge for a year because you'll take it to hearing, which you always do, so.
Well, and I may win too, but which is a separate issue, but I'm telling you, I have every reason to think that you'll never see this licensee there for a disorder or anything of that nature. It's just not, he's had too good a background in terms of his other businesses to make, to have problems in this one.
So you don't know previous licensees at all?
No, not at all.
How'd you find out about this place to buy it?
Well, I have business in the community, I work in the community.
Yeah.
And I often stop in, from time to time to have a cocktail, so I know off the establishment, so word was going around that it was, so that's how I got wind of it. And if I may, just comment regarding Jasmine, the manager.
This is Mr. English.
Good afternoon, everyone. From my understanding, she didn't serve in any management capacity while she was there. So she'd be working directly for us, taking instructions from us. So it'd be a whole different operation. And what I intend to do, because I have some restaurant background, is make the kitchen a bigger part of what we do there.
You do have restaurant background? I didn't see that. What is it?
Well, I own a seafood restaurant in Uniondale. I may have not put that on there.
It wasn't for the last 5 years, though.
Yeah.
I do ask that any history that's,
It's
relevant to
over
this
7,
business.
it was probably 8 years ago.
Was it licensed?
If it was licensed, yes. No. If
By us?
If the rest, no, it wasn't licensed by you, no.
It wasn't, you didn't serve alcohol?
No.
Oh, okay.
No, it was a seafood restaurant.
Okay. Well, they serve alcohol at seafood restaurants.
No, it was just a takeout, restaurant. So what I want to do is, I want to get more from the kitchen that's there.
So you're going to cook? That was my next question. There's no chef. You're the chef? Okay.
I don't want to be, but if I have to, I will.
So who's going to cook?
Well, I'd hire a chef.
Okay. Well, I mean, it's not a restaurant, so you don't necessarily need one, but.
Yeah. But the point I was trying to make is that I'd want to incorporate more of the restaurant and not so much, of the bar business. So that'd be different from what the, I guess, previous operation was.
This is a bar tavern, right, Jackie? Yes?
Yeah.
All right.
So Jasmine, I mean, she's worked there since 2014. This is contrary to what all of you are saying. In her questionnaire, she says she's worked there from 2014.
Oh, excuse me, 1 second.
But you guys are going to be there full-time, at least one of you?
100%, yes.
That's not what the application says.
It doesn't?
With Lenroy?
10 hours per
Lenroy will
week.
manage 60 hours per week.
Yeah.
Yeah.
And
longer in reality.
you have any special relationship with this manager you're hiring?
No, absolutely not.
Again, if you want someone else, then they'll go get somebody.
Yeah, that wouldn't be a problem at all.
No.
I don't know. I don't
Yeah,
feel
I'm
like
not
that's
gonna
fair. She's
cost
not
her a
here.
job, yeah.
Yeah, I don't want to.
All right.
You ready to vote?
Get angry. What are the hours? Sorry.
From 12 to maybe 2, because I want to get some lunch business in there.
But we generally don't care when you
yeah, I
open.
don't
It's
care when you
more
open.
about when you close.
7 days, 2 a.m., 7 days?
Yeah, 2, yeah.
7 days a week.
I'm gonna vote to. Do they need security guards?
They have, it's not two.
It's not in here.
Yes, it is. On Thursday through,
Well, it's not on the paper that I have, so it may be in the paper you have.
well,
So 2 security guards,
They do.
2 a.m. close, recorded music, no DJ, no dancing. I vote to approve.
2 security guards every day?
The method of
what
operation
was
said
yours?
Thursday to Saturday.
Fine, fine, Thursday through Saturday, but no DJ, no dancing.
Okay.
Commissioner Ford?
You can keep Jasmine.
Thank you. She'd be happy.
she's a good person.
It's okay, we'll
How
hold
do
you,
you know?
we'll hold you responsible.
You always hold me responsible.
You didn't even know she existed when we got up here, so let's not.
Chairman Bradley?
Yeah, no, I'm
All right.
good with that.
All right.
Approved. Good luck.
Good luck, guys.
Next item is 2165, Lower Level Lounge, Inc.
Martin Mailer for the licensee. There was an extensive hearing here. The ALJ sustained some charges, did not sustain other charges. I didn't even see the reasons for disapproval. I'm sorry, the report of the hearing officer until about 2 weeks ago, and I submitted. I hope you got it.
Yes,
a
we
kinder
did get
version.
it.
I'd just like to say a couple of things. This generally is a very good ALJ, but I think he went off the wagons on some of these charges. I mean, I could go on with all of them, but I do list them in detail in my letter. But I mean, things like he actually wrote the way applications work. If an investigator or an examiner has a problem with an application, they write to the attorney and they say, "Gee, we need this or we want that." I had taken this matter over. And the investigator at the time, his name was Jamie Marroquin, wrote to me and said, "Look, the diagram as written, as drawn, is confusing to me. Can you clear it up?" Which I did, and I sent a letter along with the amended diagram back to Investigator Marroquin, and the license was subsequently approved. The investigator who testified at the hearing said, "No, it wasn't on the screen, therefore it doesn't exist," and the ALJ went along with that. But there are people in this room that can attest to the fact that I have no control over whether the authority puts things on the computer screen, but when an investigator writes to me and I write back and say, here's the better diagram, that becomes part of the application. That's just an indication of some of the things that were off the rails here. There were also a number of times where the authority brought charges for local code violations, but didn't name those local code violations. And the case law is very clear that you got to, there's due process, even in an administrative proceeding, and you've got to give us the actual local laws. It's not because you violate the rule of the authority. The rule of the authority says you must obey the local codes, but at least give me the codes so as an attorney I can defend the action. I'd also like to address the issue of Focal Point. Focal Point here dealt with the fact that according to the police officers that testified, they had to go to this place quite often. Part of that, this establishment is within a precinct. It was one of the first precincts that had that local involvement of police in a specific area. And the police officer in charge of that actually came to Joshua Singh and asked him, "Is there anything I can do here?" And he says, "Well, at closing, between us and there's another place across the street, it does get kind of, there are a number of people that are on the street. Could you have a car there at the end of the night?" And they said, "No problem." And they did. And then now that has become.
Well, there was a lot more than that.
Well, but
there was public urination. There was a lot of 911 and 311 calls. I mean, even if what you're saying is accurate, there's a lot of other reasons they were there as well.
Mr. Chairman, I'm not going to argue that they made these allegations, but when I asked them, give me specificity, I wasn't given any specificity as to time and places.
They did 2 compliance inspections in a year.
Well,
in less than a year. I'm sorry, 6 months. That indicates that there's a problem. Now, some of the stuff you wrote I didn't disagree with. Some of it, that I disagreed with. So I'm going to go through and you can, after I go, you can add on whatever you want to add on.
Fair enough.
So I'm going to sustain 1, sustain 2. I'm going to dismiss 3 because I think you were correct with the improper conduct. I'm going to I'm going to dismiss 4. Because I think you also are correct there. I'm going to sustain 5, sustain 6, dismiss 7, sustain 8, dismiss 9, sustain 10, 11, dismiss 12, sustain 13, which is dancing, sustain 14, sustain 15, sustain 16, dismiss 17, sustain 18, 19, 20, 21, dismiss 22, sustain 23, 24. I'm going to dismiss 25 because I do believe that you're correct with that diagram. sustain 26, 27, 28, 29, 30, 31, dismiss 32, sustain 33, 34, sustain, dismiss 35, withdraw 36, dismiss 37, 38, 39, sustain 40, 41, 42, 43, 44, 45, dismiss 46, sustain 47, 48.
All right, I don't want to address, that I disagree with some or agree with some, but most of these were technical violations. For example, you sustained charge 41. Charge 41 called for an inspection by the fire department on a certain date. The licensee was there on that date. The fire department didn't show up because there was a snowstorm. I'm just using that as an example of, okay, we disagree as to charges 1 and 2, but I would hope that if you're going to mete out a penalty, that it be some sort of a fine.
Well, what does he have pending, if anything?
Well, just the one. We finished it yesterday.
Oh, I didn't even.
Right, no, but when you say a couple, there's only
I think
one.
I see 3, but I don't know if they're being.
I can say it because Mr. Amaretto has these cases, and he told me he was surprised that we've been very good. He doesn't have any new ones down the pike. He hasn't had one, and again, it was because of the cooperation between the police.
Well, what was the one you just finished? What were those charges?
It was, I think, it was actually it was a very interesting one. It was focal point for one day, and I mean I can't say what the
No, I
they're
know,
gonna
but
do,
this has got to also be a financial decision for him, because if they are bad enough, he's probably going to lose a license down the line if I fine him today.
I realize that. I don't. The one that was completed yesterday, I don't think is going to be. I mean, that's just my opinion, but I don't think that's going to be an issue. It was a very weird set of circumstances. The only person who testified was a police officer who came yesterday, and he said that he didn't see anything, but he was told that other things had happened. Look, I can't speak for the ALJ on that one, but I don't think that'll be an issue. And to my knowledge, that's the only one that's left.
I see others that you've put notices of appearance in as well.
Yeah. Are you sure they're not completed?
That I can't tell always from here, but I see a bill of particulars went out.
I really don't think.
I largely concur with the chairman. I looked through all your controversies here, and I agreed with you on more than usual myself, to be honest about it.
Thank you.
Charge 28, the one about the fireworks, the sparklers. Tell me about that.
It was sparklers. This investigator who went in has a thing for those things. He calls them dangerous fireworks. They're sparklers. I'm not going to argue that technically they may come within the range of fireworks, but they were removed.
Were there
It's a birthday. It's a birthday cake. You put the sparkler in, and that happy birthday. I mean, that's what it was.
Or people dancing around the room with them in their hand and light up
but
the
nobody was dancing around the room with sparklers. They only used it for. They've removed them, but that's what we're talking about. Putting a sparkler in a birthday cake. And I mean, all right. Maybe it's things like unauthorized use.
Or is this all fixed?
Yes, everything.
The wiring,
everything is up to code. Look, I'm not going to get into your investigator, but he's not a fire department official. He's not a health code official. He's not.
Well, he is qualified on many of those things.
Mr. Chairman, he takes the same
He's been trained on the fire department codes.
But if you read the administrative code, the only officials that can speak of violations is the fire department.
The bigger issue is the focal point, the sustained pattern and noise. I mean, the fact that the community board actually wrote us a letter
in 2010.
Yeah, well.
No, but that was another thing that he sustained.
And this stuff is all from October of 2017.
Right.
And they did in October they did an inspection, and then they did another one in March. And based on what Council Riano's saying, nothing's changed.
No.
Because we got charges after that.
I believe it's
when the police shut down your place and go through it with a fine-tooth comb.
They didn't shut it
You're
down.
on notice.
They didn't shut it
Well,
down.
whatever, but they did the inspection. You're on notice that something's not right here.
Believe me, Mr. Chairman, they're in compliance with everything. There's been no complaints about this place since April.
Where are you guys?
First, are we all agreed as far as which charges are being sustained and dismissed?
Yeah, you.
Yes.
Yes. Yes.
All right. so-
I mean, given that there's more coming down the pipes, I do agree with the chairman that this is a financial decision,
Well,
really.
and he does win his cases, like he said, periodically, so we never know.
That's true.
Okay, but,
Squirrel
you
gets a
know,
nut, right?
in my opinion, your credibility is not worth
Mine or
yours.
you mean in terms of what's going to happen in the future?
I'm at 30,000.
Yeah, there's a lot of stuff here. I wasn't quite as high as 30,000. I was around 20.
That's where I was too, so you want, I'll go 20.
I'll go with 20.
Thank you. Thanks.
Next item is 2115, Chow Hung Inc.
Good morning, Commissioners. Before we start, I missed one of mine, 2120 El Marquez. Could I
You
have?
didn't sign it in?
I didn't sign it in. I missed it on the agenda.
You got to wait until the very end of the meeting now.
I apologize. Chow Hung, I'm in the process of correcting them. They've missed this one. They would have been here today, but they had a brother-in-law pass away in Wisconsin, and both of these family, their brothers, they had to go.
I guess what I don't understand about this place is I've never seen in my entire time here at the State Liquor Authority a place that defaults as much as this place.
I was just going to mention that, yeah.
I've actually, at some point in my office, gone to my associate and my partners. I'm getting to the point I don't think they read English well enough to understand that I don't get CC'd on the pleadings. Like they, at some point.
Well, then you need to change that. That's not really a defense. here.
Absolutely. And in this, I'm not even asking for the default to be vacated.
Oh,
What
that
I'm
would be
asking.
us doing that. We don't do it, right, Chris?
I'm sorry.
We don't CC the
No,
attorney.
unless I put in a notice of appearance. They finally are starting to understand
I mean, their
that.
history is atrocious.
It is, and that's why I would.
It's a default after default after default. I mean, we do have some continuing cases of not guilties. I see here where you filed
that
notice of
I've
appearance.
got.
That's
And actually, I appreciate.
Mr. Chisholm, it's not just the pleadings.
I know
Okay?
it's the
It's the
fines.
penalty letters.
The penalty letters too, which they assumed I was getting CC'd on, and some I were, some I wasn't. As I said, Counsel Riano at one point informed me of a bunch of pleadings that were out there that I got on them, and I did get answers in on. This is the one that didn't. I would ask for a large fine and maybe a suspension of the license for a week or two instead of cancellation or revocation.
Chairman, could I ask that you consider also directing the licensee to get, whether it's going to the UPS store or one of those places, to get someplace where mail can get delivered?
Yeah, the problem isn't just them not reading English. There was no way we could deliver this. The
I
Postal
will-
Service said it was unable to deliver, and then obviously they left a notice, and nobody went and got it.
I will address that. That I did not know. I will address that with them as soon as I can get hold of them on the phone, obviously there.
Chris, how many cases do we have here? many?
You've noted your appearance on two, I believe.
I think there are two
Is that fair?
future cases there. One's on for October 30th, and I believe one is on for November
Or I think
16th.
three, actually. I'm sorry.
Is it three?
It might be, I think it's three.
It might be, I think
And it's
Stan
Silver
Moretto
Miner.
has two, and new.
Well, I'll give them 20,000 because they're not getting the message. And if they end up losing those cases, they're probably going to lose a license.
I understand that. I appreciate that, Your Honor.
20,000.
My notes on here was, this place should be closed.
I understand that, Commissioner Ford. I do understand that, and I am asking for the deference of Your Honor to give them one last shot on the three other cases.
If 20,000 doesn't get their attention, then.
What's your
nothing
other
will.
number?
2120.
2120, El Marquez. And I believe it's a sale to, it's their second sale to a minor. No letter of contravention was put in. I did the hearing. Is it the third? I'm sorry, I was just looking at this one. Oh, no, it's the third sale to a minor. Yes, I didn't, I'm sorry, I misread that when I looked at it.
Three times, yes.
I did the hearing on this one. I did not do the two prior hearings. I have gotten a new security company in
License
there
expired.
to correct it. And all these were undercover, so I can't even argue, we did the hearing, they presented the evidence. This particular one is what it is. I brought in a new security company. I've explained to them, they are in the process of getting scanners. As far as I know, they
All
are.
right, 10,000.
Thank you, Your Honor.
10,000.
10,000. And
right.
Secretary Donahue, I was okay with 20,000 on one before that, by the way.
Yeah,
Okay.
Thank you very much.
Thanks.
Our next item is 2102 Dominican Meat Market, Inc.
Good morning, Mr. Chairman, Commissioners. My name is Laquan Lund, and I represent Dominican Meat Market, Inc., doing business as Jerusalem Fresh Market. I'm here with the principal, Mr. Esposito Batista. This is an application for a change in class from a grocery beer to a eating place beer. My client runs a restaurant.
Have we heard from the village?
We have not heard anything from the Village of
Is
Hempstead.
that generally what's been happening lately? So we don't hear anything on their stuff?
Radio silent.
I did
Don't
meet-
have anything.
I did meet with Deputy Mayor Charles Renfro on the premises, I believe on Monday, who did do a tour with me. We did talk about it, and he said, as far as I know, there is no opposition, but he said he would reach out to me if there was any opposition to this.
Why does he want to change this?
Well, my client has, he has 2 tables. He does have a counter space where 12 people can sit and eat. They do currently eat on the premises.
He currently is serving food there?
He is serving food there. People do eat there, but they do not drink beer on premises. They drink soda, water, juice, things of that nature.
How long has he been open as a grocery store
I believe
license?
it's been open for about 3 years.
Almost 4.
Almost.
We're gonna be 4 now in December.
And what are the hours of the store?
7 a.m. to 10 p.m. That's correct. My understanding, he's had no disciplinary actions or adverse
No.
with this
No.
establishment.
No, I mean, the reason this is here, I'm assuming, is because it's the Village of Hempstead, is that?
Correct.
Correct.
Yeah. So I'm going to stop that, because they're not responding, so you can just do these locally.
All right, so I'll send a revised delegation?
Yes,
At one of
because
the next
I don't think they've contacted us in 6 months or more. All right, yeah, I'll approve this.
Yeah, I don't see any problem with it at all. Good luck.
Thank you.
Yes, vote to approve. Thank you.
Thank you. Have a good day.
Good day.
Next item, 2164 Alta Cucina 2 LLC.
Good morning, Chairman, Commissioners. This was put over from the last meeting, so.
Do we need to hear from Mr. Booth here?
Yes.
All right.
Okay, thank you.
So, Mr. Booth, is your only objection to 4 a.m. closing?
No, go back to the 200-foot rule. Darn it. I actually put together, I'm sure if your investigators had, and Carter Booth, Community Board too, if your investigators have gone out and looked at the same information that I have, I think that if I can provide you with some copies.
Well, they
of
actually did, correct?
That's the memo from the
And
council's office.
the information we have is the school door didn't, while the renovations did occur over the course of that period of time, the school door didn't move till 2000.
But we're not talking about the door that moved. We're talking about the school being a corner location. And that is what put it on both.
But it goes on when the
6th
door-
Avenue and Bleecker Street. And the corner location was part of the school since 1971. And as the crow flies from the school entrance from 196 Bleecker to the original restaurant entrance, using the tools that are provided by the authority on your lamp system, all the measurements that I did came out to be under 200 feet.
There's no question the door now is under 200 feet.
No, I'm talking about the original school door.
The information we got from our investigators is not the case.
If I can show you the pictures, I mean, it's pretty straightforward.
I don't know that it is. We went and had somebody sent out, didn't we, Chris?
I worked with Mr. Ferring on this. He went
And
through his
and you went
documentation.
and he went back through the records, the historical
records.
records. So you can show us pictures, but I don't. The information that I have is that this is grandfathered in, and it was already dealt with correctly on a declaratory ruling.
The information that you reviewed that was submitted as supplemental information for the declaratory ruling is just wrong. The facts aren't. I mean, the facts are in front of you as far as the.
Well, that's your view of it, but when this was done, I'm assuming that our counsel's office did it correctly with the investigator going out and doing the measurements and looking through the public records,
We have a
correct?
declaratory ruling, as far as I know.
But the declaratory ruling, I mean, the information that you're provided is just not accurate.
But
That's in
then,
there. so-
that is something that needs to be done through litigation. It doesn't get revisited here.
Chairman, just to clarify,
That's-
when the rulings go before the members, we don't investigate anything. When the original ruling went before the members, the facts are what was presented.
Correct, but we went back out and she sent an investigator back.
No, I understand, I'm just saying,
But the premise is that the determination that was made before is that the school is not on the corner, and the school is on the corner. It was on the corner since 1971. And that was the whole point
right,
of
but
the original.
what counsel's office is saying is that even if it was on the corner, the entrances were more than 200 feet apart.
At that time.
But that's, I mean, this is just, the information that was provided to you by the applicant is wrong. The supplemental information that they provided to you for the meeting
And I just said,
last
if that's
year-
the case, then the proper method is to litigate the declaratory ruling, correct?
That's fine.
Well, I mean, wouldn't you guys check the work?
We
I mean,
did. And I'm telling you that the door was not, that our counsel is telling us that the door at the time,
Which
it
door?
did not move till 2000, the door that's used by the school.
But
Jackie, can
that's-
you just
that's,
explain what was found, what was done, and what was found?
Well, that would be
Clear.
Mr. Ferring, which
Yes.
should be here to do that.
Okay.
So which doors? There are 5 doors into the school that existed in 1975.
The door that makes the school within 200 feet of this location was not used until 2000, is the information we had.
But there are 5 doors that existed in 1975.
And
And the
from what
name-
we're told, all 5 of those in 75 were over 200 feet away from this location.
They're not.
Well,
I
then
mean,
you
that's a
should have
fact.
been,
It's a-
but you're
But in 1975, you're saying that it was not on corner property.
You know, it was.
Saying
The
it
school
was.
was, and your information says
Well,
it's
then you
not,
need to
and it's-
litigate the
It's
declaratory
not a
ruling.
litigation. The facts are in front of you. There's a.
We already made a declaratory ruling that
Well,
this is grandfathered in, so you want me to overrule that right now based on your representations?
The facts are in front of you. I think that you should
You're
actually
saying
have
they're
your
the facts,
counsel
but you're
office go
telling us
back
the
and check
facts
it.
that were presented before were wrong.
That's right.
Well, so I'm supposed to believe you over my own counsel's office?
Actually, you don't have to believe me. The facts are in front of you. There's a certificate of
drafted this.
occupancy. There's a certificate of occupancy from New York City. It's dated in 1971 that indicates 200 to 202 Bleecker Street is a school.
But you want me to overrule a declaratory ruling based on your submission that was already ruled upon by this board over how long
with
ago, a
incorrect
year?
information. You've made that determination based on information from
But
the
then you
applicant.
litigate it. You don't do it here and try to do it when somebody else is applying. Then sue us. I get that.
We brought this up in the very beginning.
And I went and checked it.
In our,
Listen, Mr. Booth, I told you the way out of this. If you don't want to go in that direction, then that's fine.
well, the community board can't litigate because we're a city agency.
Well, then
And
one of
so
your,
what we're
certainly
asking
the
for
public
you
can
is to
litigate,
actually
correct?
to have a correct.
Am I wrong here in the process that's supposed to be done?
I mean, this has already been decided. I think it's ridiculous to relitigate this here.
It's
I'd be
not,
happy-
but it's not litigating. You determined it on facts that nobody.
Yeah. Let's take a break.
Just as a reminder that this was adjourned at the last meeting because we weren't given an opportunity to be heard at the declaratory ruling. That's why we're here today. And the declaratory ruling was ex parte based on
Well,
facts that were incorrect.
if this gets approved, there are legal options that the school can take, there are legal options that the residents can take that would justify if the facts were wrong that we
Wouldn't
made
you
the
wanna get this
determination
right?
on.
Wouldn't the authority want to get this issue right?
I believe we did. We had somebody look at it again. That's why we adjourned it, and I believe we
Okay.
did get it right, and
And
we
what
are now
was
going to move forward.
Okay,
What
well,
other
I just had one question,
Mr.
is what's
Booth,
the
I'm talking right now.
Okay.
Can you move on to your other objections?
The other objections are outlined fairly clearly in the Community Board's resolution with respects to the hours of operation, with respect to the hours of operation of the Sidewalk Cafe. I think that the applicant had already agreed to closing at 11 p.m., the outdoor areas, 7 days a week. And, that they had, when they came to the Community Board, they also indicated that they were going to have some sort of a private dining room in the basement, that there were no permits that allow any use in the basement. So until they're able to produce some sort of documentation with respect to use of the basement, they shouldn't be allowed to operate down there. As you can see from the pictures that were submitted, this is a large, it's a very large restaurant. It fronts across 3 different storefronts. 2 of the storefronts are not connected to the 3rd storefront.
What were the hours of the other restaurant?
For which other restaurant?
When it was Dal Salvino?
They usually close by midnight.
Did they have
1 o'clock.
license hours or no?
I'll look.
When they came before the Community Board in 2000 to expand into the southern storefront, that they said that they would maintain their hours of operation, which were midnight and 1 o'clock. That time period is very comparable to the restaurant next door, which is Bar Pity.
And what were the outdoor hours?
Closing at 11 o'clock, 11 p.m.
That was the old restaurant, or that's what
That's what this applicant had agreed to when they had presented their Sidewalk Cafe application before the Community Board, which was after they had appeared before us with.
Sorry, they're closing the Sidewalk Cafe at 11, or they're closing the whole restaurant at 11?
Sidewalk Cafe.
Oh, okay.
The record reflects in 2008 that the licensee had agreed to reduce its hours on the weekend to 2 a.m. in light of community concerns, and that's part of a resolution received from your community board.
For what was the, that's for this applicant?
No, this was the prior.
For
I was
Da
asked what the
Salvino?
hours were for the
Right,
priors.
For Da Salvino?
Mhm.
Okay.
The windows don't open, do they, in the front? The 3?
The whole facade opens.
The whole facade opens? Do you have hours on closing of the windows, et cetera?
You said here by 5 in your recommendation, by 9, I'm sorry, in your recommendations.
Yes.
By 9, oh, I see, got it. Okay.
Anything else?
I'd just like to know what the distance is between the doors.
It's, right now, it's under 200 feet. There's no question about it.
No, in 1975.
Off the top of my head, I have no idea. I'd have to look at the declaratory ruling, which I do not have in front
the
of me.
information that was provided to you, that it was 457 feet or
I
something
told you I
along
don't have it in
those
front of
lines.
me.
No, I'm just saying, and that's clearly wrong. So,
Sorry.
Yep.
All right.
Okay, so we met with the community board. We're still gonna operate a full-service restaurant here. There's no live music, there's no DJ. We did agree to close the outside at 11 o'clock at night. But the thing is that we couldn't agree to close earlier than 4 o'clock, and that's what this really all came down to.
Well, you're not getting 4 o'clock.
Okay,
That I can tell you.
I understand that.
So what did they want?
They wanted us to close at midnight, 7 days a week, and they simply cannot do that. So if we can just, demonstrate and everything else, we'd be willing to do the 2 o'clock on the weekends, and then 1 o'clock during the week. or 2 o'clock 7 days a week.
What about closing the open facades by 9 p.m. every night and the sidewalk cafe by 10?
Well, we agreed to the community board already to close the sidewalk cafe at 11. We've already agreed to that with them.
Okay.
And what's the music situation?
It's background music, no live music.
Okay, I don't have anything else, you guys?
Nope.
Ready to vote?
Yep.
Commissioner Fan.
Based on council's office finding the declaratory ruling was upheld and reconfirmed to be accurate, so I am going to vote to approve with no dancing, recorded music only, windows closed by 9 p.m., 2 a.m. across the board. I think that I live in the area. I do feel that there is need for viable businesses in this area, as we see a lot of empty storefronts. And so I wish you the best of luck.
Thank you.
Say that again, you're 2 a.m. across the board?
2 a.m. across the board.
I'm fine with all of those as well.
Okay, thank you.
Chairman Bradley?
I'm fine with it as well. You should be on notice that, and I'm with Commissioner Fan. I have confidence that our counsel's office went back and checked this and was correct, but if we weren't, we have no discretion here. He would
No, I
lose,
understand
he'll
that,
lose
but
his
that's...
license.
No, I understand it, but that's to say that this agency was wrong for over 40 years.
That, and possible. Believe me, that's possible.
No, I understand, but literally...
I've been in government a long time. It's possible.
I understand, but literally... Let me finish speaking, please. Let me finish speaking. Thank you.
It's possible is all I'm saying.
I
so.
understand it, but again, work closely with counsel's office. The school was always on the corner. There was never an entrance
Okay, we're
on
not
there.
going to relitigate it now here, as I
Wanna make
told
sure.
him, but
It's okay.
my point is, if it happens,
Don't get
then
angry.
he's going to lose the liquor license.
No, I
He can
understand.
do wine and beer, but,
No,
okay.
I understand. I get it. Thank you so much. Everybody voted? Good?
Yes, yep.
Thank you. Jack?
Next item is 2119, CNA 1067 Wines and Liquors Corp.
Good morning, Leonard Fogelman for the licensee. This is Ms. Soto, who is the licensee. We had a hearing. The judge sustained the charges. I sent in a letter of controversion where I certainly stated in rather precise terms that we thought the judge was wrong in several of her conclusions.
Well, I didn't. So I'm going to sustain 1, 2, and 3. I don't know what was going on here.
Well, we've had, it's really
I mean, what I'm going to tell you what I think was going on. That her mother-in-law, well, was.
She's not my mother-in-law. Never married someone.
she was not married.
Oh,
It
well,
was her-
whatever, but-
Whatever the relation, it was.
Had her file an application because whatever you want to call her already owned a store. And she was the front for the mother-in-law. Am I getting that correct, Chris?
I mean, I'm fine with the way they.
And then when she shut her own store and you disappeared, she tried to take that store out from under you. Or you went to Puerto Rico for 3 weeks, or however long you were there. But the whole thing was illegal from the beginning.
She applied for a liquor license with her money
Yeah, but her, whatever you want to call the woman, the mother-in-law, whatever you want to call her, she was signing checks for the store. She was involved in it from the beginning. So what does that tell you? How did she have the right to sign on her bank account?
She had signed over one check from the store, and she put.
She signed the lease.
The application, the lease was signed by her, the money was provided by her, by her bank account. She applied for and documented and was approved by the board for the liquor store with her money and was running the store. You have there's testimony about the fraudulent background of the quote-unquote mother-in-law. The authority has rescinded the corporate change because the authority determined that there was fraud involved. That the application for corporate change was full of fraudulent signatures signed by the quote-unquote mother-in-law.
Well, I mean, I obviously did not hear the testimony the ALJ did, and I think, based on what I've read, that what you're saying is not an accurate statement of what was going on. So in my view, and I don't know where they are, I'm at revoke and bond with a prescription, because I think the landlord was compliant in this as well. Am I wrong in thinking that?
Not as far as I can see from the decision.
The landlord gave a new person a lease.
Exactly. Exactly. So he was complicit in the whole thing as well. Because I don't think she ever had any intention of running the store. I think she was doing it for her mother-in-law. So the mother-in-law could have two stores, which is also where we get to the point that we have the purchases from unauthorized sources. So this whole thing was a facade, and you all got caught because you started fighting with each other. That's what happened.
Yeah.
So I'm at revoke and bond with a 2-year prescription.
Commissioner Fan?
Yeah, I agree with the chairman that this agency is really not to be used to resolve your family disputes. I'm at revoke and bond.
With the prescription as well?
Yes.
And Commissioner Ford?
My notes here was everyone involved here should be canceled. So I'm going to go with Chairman and Commissioner.
And the other woman does not have a license, correct, Jackie? That's the one question I had.
Who has a license?
The other woman that was involved in this?
Mary?
I have a license.
Soto.
Soto. Got it.
Who are you referring to?
Miss Soto, she does not have a license anymore, correct?
No, I am a Soto.
Oh, then Miss Thiverson. She doesn't have a license.
Doesn't have a license
Okay, because we were going to get that one too.
Yep.
Thank you.
Next item is 2178, Heroes Place, Inc.
This, I think, is a lot simpler. We have a offer of a $1,000 settlement.
I'll accept.
Accept.
Thank you very much.
Next item is 2163, ABMM and Sons, Inc.
2163.
It's out of order. 2163.
Good morning, Neil Trivedi for the applicant. This was put on for last time. I think it's because the application is in the village of Hempstead.
This is another one where we've had radio silence.
This is one I did not follow up and talk about.
So
No new information on file.
who owns the store that she's the cashier at?
That's,
I asked her. Who owns the store where you work now?
this one.
JMH Dali.
Who is that a relation?
Yeah, my father-in-law's friend.
It's your father-in-law's friend? And what does your husband do
He's helping me out.
at the store?
And he just got a license also at B&D Deli that I just picked up a couple of weeks ago.
Where's that?
That's in Oceanside?
Long Beach.
Long Beach.
You're going to be there every day?
Location is right across from 99 Main Street in Hempstead. It's near the court area. It's only open from 7 to 7. Weekends is quiet, and weeknights it's quiet also.
So I started checking the emails now that it's been 2 weeks ago, and I noticed you're using your husband's email. Is that correct?
Well, he's my contact person that I've been.
So why didn't he just get on this license? What's the,
Because we applied for the one on BND Delhi.
well, you can have more than one.
Yeah, I understand. There's no.
Does he have any history?
I mean, he was on the account joint holder. I did mention, I did provide personal questionnaire for the husband as well.
No, you don't see them split like this when you can have 12 of them if you want. It kind of made me wonder.
Well, it creates a little bit of liability.
Why don't you let him answer? Why are you on
License
it?
was picked up on 10/10. It was issued 10/10. He has nothing prior to
Oh,
that.
okay.
If the
So this
contact is
brand new.
him.
We both are using same
Same.
emails.
Yeah.
I have her login in and she have my login in. So we always check it.
No, that's not illegal to use your husband's email. What we're saying is, why wouldn't you just put your name on both licenses?
Because I just did on that one. That's why I thought I should go with her.
Okay.
I mean, also.
How long have you guys been married?
3 years.
2 years or 3 years? 3 years. It's nice to have each other's passwords.
I'm not even going to comment on it. I'm not going to comment. No, yeah. All right, I don't have a problem with this. I'll approve.
I'll approve as
Be
well.
careful with the underage sales.
I'll approve as well.
Thank you so much.
We got two items that are related, 2130 and 2131, USEF Convenience Store Corp.
My husband doesn't have a password. Yeah, I know.
Yes. 2130 and 31?
Yes.
Yes.
So 2130,
Did we get the 7,500? Yeah.
His office has it.
yeah.
All right, so I'll grant reconsideration on that.
Back to licensing?
No, that's.
No, this is for the recon, so this is, we're accepting the original offer and rescinding the cancellation.
Okay,
Yep.
same here then.
And
All right, and then this can go back to you, Jackie? Oh, no, we have to grant this, okay. So I'll grant this. Since your history, it got canceled because you failed to pay a fine, which you now have paid. And prior to that, your history wasn't too bad.
So are you going to send it back to licensing?
No, I
No,
think
you
it's for
have
us
it to
to grant it.
decide.
Yeah, I'll approve.
I'll approve.
I'll approve as well.
Done.
Good luck.
Thank you.
Next item. 2173, Restaurant Del Mora, Inc.
Timothy Allen for the licensee. I'd ask to put this over one time.
Why?
I'm sorry, 2173?
2173, it's a
This is
default.
a default.
I just saw it on the calendar. I'm actually here on the next case. And this is my client, and it says it's a default. I just want to investigate what it is.
I'll put it over. But
November 6th?
11/6?
Yep. Yeah.
All right. 2162, A New Sunrise, Inc.
This is a disapproval. The owner's here with me. So what happened was it was approved, and there were like 11 temps issued because he was working on the C of O. And as you can see, the main problem after that was that he received, I believe, 4 summonses for after hours. But the problem is it's the establishment with one address is side by side, a restaurant and a bar. So at 4 o'clock, they closed the bar, and he was trying to operate the restaurant 24 hours. So I think that's, where the problem stemmed from. But he just, in September, got.
But what are you doing, what do you want us to do here? This is a disapproval hearing, right?
Right.
And I didn't disagree with the findings, so you can't get reconsideration now.
Well,
I mean, I'm just going to uphold, I think there was a rational basis for the decision that was made, which is all he was required to do, and he did, the ALJ did or she.
including documents which they basically don't accept because they weren't presented at the time of the license
That's what the law
application.
says.
I understand. And we would ask it to be reinstated without a temp because he can get the C of O now. He had an inspection in September, so he would have the C of O.
Well, then he can
pick up
reapply. I mean, this is, how long was the C of O outstanding?
A year.
A year? Yeah, I mean, and we're getting, that's getting crazy, and we're going to try to do something about that. But we can't have people on temps for a year because they can't get a C of O. That's not our problem, and you have to have the C of O.
He had a C of O, but unfortunately, it's from 1966, and it says 20 persons accommodated. That's the problem with it. So.
It shouldn't take a year now. I don't know whether that's on him or on the Department of Buildings.
He had plans with him, and the architect I spoke to, and he sent me they did an inspection in September that he passed, and it still needs final approval, still needs final sign-off, which they're telling us.
Well, then I'm not going to open him again on a temp. He can reapply once he has the C of O, and I'm going to adopt the findings.
Commissioner Fan?
I agree.
And Commissioner Ford?
Same here.
All right, thank you.
I'll adopt them as well. Thank you.
Next item, 2106, Shlomo Grocery, Inc.
I need to take a pause after this one, too.
You need what?
Take a pause after this one, yeah. 2106.
Good morning.
Morning.
Go ahead.
Go ahead.
I don't know.
You put your name on the record?
Okay, Paris Hamtini, attorney for the applicant. And Simon, applicant.
Is he aware?
What happened here before?
Well, I know he's aware of it because it was his father.
Yeah.
Correct?
Your Honor?
Well, his father got arrested for welfare fraud. Are you aware of that? Is this the first time you met him?
I'm sorry, Your Honor?
Is this the first time you met your client?
No.
Or are you
Like
not familiar
during
with?
the application, yeah.
You did the application for him?
Yes.
Are you aware that his father was licensed here?
I'm not aware.
And that we took the license?
I'm not aware.
He wasn't licensed. He was working there. But he's not there no more.
Yeah, my client's saying he was not licensed. He was working there.
Well, the information we have is your father was the licensee.
Somebody else had the store. He was working there as an employee.
Then why was his name on the license?
He sold the store a long time ago.
Why was his name on the license?
Which license, Your Honor?
The liquor license. Your father's name was on our liquor license.
Back in when?
When we canceled it, back in
2016.
2016.
Yep. Khalil Ashur, right?
That's not my father. Khalil Asfour.
It's not your father?
That's not my father.
Is he a relation of yours?
No.
You have the same name?
What's the name?
Khalil Asfour. That's not my father.
What's your father's name?
Samir Shaheen.
You have a different last name from your father? Okay.
So Khalil Ashfour,
Khalil Asfour was the previous owner 2 times ago.
and you're not related to him?
Relationships with him.
Are you related at all?
No.
Do you know who he is?
No. I know he's the previous owner.
Is that a common name, Ashfour?
Arabic. I'm Arabic.
Is it a common name, Ashfour?
Usually, yeah. If you're Arabic.
I've never seen it before. That's why I asked. And you have the same name as the former owner.
Yeah,
Did you work there for him? But your father did? Did your father get arrested? Ever? Yeah, no, for welfare fraud. What the hell's going on here? And your father's name is what?
Oh, my gosh.
And he worked for Ashford at the time, Khalil Ashford, and they both got arrested for welfare fraud. Then how did we cancel, we canceled on the employee getting, oh, because they were using the store for the food
No,
stamps.
he got arrested.
I think they got up, yeah, as far as I can tell.
I have,
Where's your father now? What is he doing?
I'm sorry, how do you spell your father's last name? Right, so he, yeah. So if you look in the memo from the prosecutor's office back from February 2016,
yeah,
Mr. Ashford got arrested for one
Yeah, I see that,
bunch of
right.
felonies. They turn a page, and then the applicant's father was arrested for.
oh, and he was the availer. Your father did own the store, or he wasn't on paper as owning the store.
Samir Shaheen, yeah.
Are you aware of all this?
And they're cousins.
Cousins too, yeah.
Very confusing.
So you are related to Khalil Ashford.
Well, he's your father's cousin.
If he's related, how are you not related? That doesn't make sense.
Is he your
Under all
biological
cultures,
father?
You would be related. I
So
don't
he's
know
a
if
blood,
to deny.
you're a blood relative? Your father is you're a biological son of your father. And your father is related to Mr. Ashford. He's his cousin. Correct?
That would make you.
That makes you a
second
cousin. Yeah, I'm with Commissioner Fan. It's, I'm not going to try to unwind all this, but there's something not right here, so. Well, what it does have to do with is that we canceled the license here before. His father was availing that license previously. He just told me he was not related to the guy who owned the store on the license before, yet he is. There's just too many we don't knows here, and we're not going to give a license to a relative that we took previously for availing and for welfare fraud. So that's what's happening here. Well, we all have histories, and your history follows you, and it's... No, you probably should go find another store. That would probably be a better idea. Then maybe I would listen to you, but I'm certainly not going to give you the store that your father had illegally 2 years ago.
Yep.
Thank you.
We're all set with that?
Yep.
All right.
Denied.
The next item is 2132, Prestige Sports Bar, Inc.
Oh, you want a break?
I'd like to, just for a minute.
All right, we are back on the record after a recess with 2132 Prestige Sports Bar, Inc.
Good afternoon, Mr. Chairman, Commissioners. My name is Michael Finkelstein. I stand here on behalf of the licensee, Mr. Jose Colano, Prestige Sports Bar. I have to apologize immediately to the board. Between the first hearing and the final hearing before the ALJ, my law office, we sort of had a parting ways. And my address changed to 666 Old Country Road, Garden City, New York. It was only Tuesday, on October 23rd, this past Tuesday, that I spoke to Mr. Donahue's office and found out that there was a decision, and the decision was coming before this panel for this board today. I got a copy that was sent over to me, emailed to me. Unfortunately, I did not have an opportunity to write a written controversy. I had an opportunity to review all of the findings of the ALJ. Most of them, I do agree with. One of them, in my opinion, is contradicted by two of the other things that the town did not sustain. But for the most part,
So which one do you disagree with?
number 7, which deals with supervision, because he found number 14 and 15 not to be sustained. 14 and 15 deal with the licensing that was being held by the security company. And number 7 dealt directly with the security company.
But you don't think the failure to comply with the local regulations is a lack of supervision?
What was explained to me during the hearing by Mr. Amarato and his argument was that they didn't have licensed security guards on the premises, which we presented to the panel and to the ALJ a copy of the licensed agreement between the security company and my client, which stated that he had licensed security on the premises from 2007 all the way through. And that's why they didn't.
Well, I mean, what I'm saying is there are other charges in here that were sustained that support the failure to supervise, in my opinion.
I understand, Mr. Chairman, but at the hearing, that's not how the argument was addressed.
Oh, well.
It was addressed for,
But the way that may be, but the way the ALJ decided it, he used other charges, although he does appear to have used one of the charges that was dismissed wrongfully, but he also used charges 8, what was it, 7? He used charge, oh no, I'm reading the,
if you look at charge number 7 on page 8, it clearly indicates that he asserted the licensee had always used security services through the MAS security system, which is how it was addressed at the hearing and presented to the...
were we talking about the same charge? You're talking about the failure to supervise, correct?
Yes, charge number 7. And if you look at on page 8 of his findings, it clearly indicates, and he's discussing the...
It's on page 12 of his findings.
My copy's page
So
8.
Oh, okay. What am I reading here then? This doesn't.
You're reading two different sections. Page 12 is the judge's opinion.
Yeah, that's what I'm
And
reading.
page 8 are the findings of fact he
Yeah,
made.
I'm reading the judge's opinion, and the judge's opinion is what he based it on. It indicates what he based his decision on. Failed to comply with a number of operational compliance rules and regulations bearing on the licensed premise.
That's fine.
Failure to do so in each instance in an aggregate is not only a violation of the regulatory compliance, but also a failure to supervise.
I would leave it up to
All
the
right.
board on that.
So withdraw 1 through 3, sustain 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, dismiss 14, 15, withdraw 16, and dismiss 17.
Mr. Chairman, I'd like to say just one other thing.
Sure.
On May 9th, prior to the hearing, I wrote a long letter with exhibits to Mr. Amarato and intended not to have the hearing. The reason why the hearing went forward was because of the more substantial or more serious charges, those being 1, 2, 3, and 14, which were actually 1, 2, 3, and 16. The hearing testimony were all withdrawn. I think there was actually a problem with the paperwork, they confused this location with another location. In my humble opinion, based upon that, I don't think we would have never had a hearing because, as I'm sure this board is aware, all of the problems, all the fire marshal violations were all rectified in a very short period of time. The violations were written on October 10th. By November 8th, we already had approval from the town to reopen the premises, and it's been reopened ever since.
What about 8 and 9? What have you done to rectify that?
Food, kitchen.
We have a working kitchen with a refrigerator and a microwave. We have food on the premises. The town has been back, they've re-inspected, and there has been absolutely no other violations since October 10th when it came in. And I believe that the original reason why they came in was because of the violations alleged in 1, 2, 3, and 16, which were later withdrawn.
Okay.
So all re-inspected, reopened, doing business.
All re-inspected, reopened, cleared on 11/8/17, they've been open ever since. Just going on without incident.
Okay, you ready to go?
Yes.
Are we all in agreement as far as the charges that were sustained and dismissed and withdrawn?
Yes.
Yes.
All right. Commissioner Fan?
I take fire safety really, really seriously. Block exits, no fire extinguisher, really scary stuff. Condemned by fire marshal, but you don't see that a lot. 20,000.
Commissioner, if I may speak to that exactly. If you saw the pictures, okay, you talked about a broomstick in front of the fire extinguisher, and one had to be recharged. And
The fire department have their standards. I'm not, it's not my discretion to challenge what they found.
Okay, where are you at?
Commissioner, counsel,
where are you at?
counsel, the members are
I
voting.
was
I'm
going
at
to say
20.
15.
How much?
15.
17,000. We split the difference?
Yes, that's fine.
17. Thank you.
Next items 2126 and 2127, 417W Inc.
Good afternoon, Robert Swetnick. Just want to bring 2 points regarding this. Is that when this licensee originally applied approximately 5 years ago, the only questions were if you're going to have music, if it was going to be live or recorded. They checked off recorded. Since then, when they've been renewing, they always said that they had a DJ. So it's never been hidden. It's always been in every renewal, which you should have in your files, and the original application didn't even ask that question. Regarding the kitchen,
But you didn't, am I wrong in stating that on the DJ charge, you withdrew the not guilty during the hearing and pled to, and then,
authority's position was, which we couldn't comprehend, is that there had to be something in the application and a change in operation. We never denied there was a DJ. Again, on all the renewals at Parks, there was a DJ. They couldn't do anything in the original application. And we don't really think it's a change in operation since it had from day one. And again, I have the original.
To go back to the, sorry, Mr. Swetnick, to go back to the there was a 500-foot hearing during this application, and the only thing they indicated, there will be occasional private events where there will be a DJ if requested. So that was disclosed at the 500-foot hearing.
Right, and on all the renewals,
no, I get your argument, I just don't know why you would plead guilty to it then.
I took counsel at their word that this is technically to you a violation because there was not a change in.
Well, so I'm gonna dismiss one. Yes.
And again, the reason the investigator, when he testified, acknowledged that in the pictures he presented, there was equipment which in his written report he said did not exist. It was kitchen equipment. At the time of the hearing, and currently, we can show that, if I can hand these up, they've installed a very full and elaborate kitchen. So just in mitigation, nothing I can do with the findings, so again, we disagree with it. The kitchen was not this extensive then, but there always was a kitchen, and now there's a very extensive kitchen. But again, in his testimony, he acknowledged that he said, in other words, there was no microwave, no deep fryer, and then he did show in his own pictures that the authority presented, those appliances were there.
But this is supposed to be a restaurant.
Well, it's supposed to be a tavern, and it does serve.
Well, it's got a restaurant license, right, Jackie?
Now it's serving more.
I think that was what the point was, is that it's licensed as a restaurant, and it didn't have a sufficient kitchen for a
It was
restaurant.
submitted to the members as, because this was approved by the members as a bar tavern sports bar.
Oh, what, so it's under 164?
A.
Okay, okay. Well, then I'm going to dismiss all of them.
Yep.
Yeah.
Dismiss them all.
Next item, 2082, G+3T Corp. '2082.
Good afternoon. My name is Sylvia Matrina with Matrina Law LLC. I'm the attorney for the applicant. With me, I have two principals of the application. This is for a liquor store, total of 600 square feet, about a third of which is for storage of a small office space. And there were no protests on this application.
That's correct. So you have 5 stores in under 2 miles. Why do we need another one?
Well, the city of Yonkers is extremely large, and although they're within 2 miles, there is a lot of walking traffic within the city of Yonkers, and this is a very densely populated residential and business area, and there is, although they are within 2 miles, there is no liquor store within the immediate vicinity. They actually went around and spoke to a lot of the neighboring properties, and they had many signatures on a petition in favor of this application.
Sir, we did have an investigator go out here.
Yep, I'll take a look.
Who are the two clients?
They may introduce themselves.
Yes, we did have an investigator, sorry.
And the other two are yours family members? Oh, okay, but they have the same last name?
Who are you? Which one?
CB, so you guys are cousins, like real cousins, and the other two are not related? Okay. Why do you guys want to go into the alcohol business? You're all in healthcare.
We have been thinking about getting into a restaurant or liquor store business for a while. Spoken about it, and this is a good area because there are no liquor stores in that area. So we feel it would be convenient for the residents.
You have any relatives in the business? Do you? And where are the other two? They're just silent partners, or are they going to be working in the store as well?
They are actually working together.
Oh, okay. And you all work together? Is that how you know each other, other than your relation?
No, we know each other through the community. We don't know.
Oh, okay. This is near a hospital, right? Is this, no? I must be thinking of another application. So that one we denied in August last year was because of the 200-foot issue?
Yes.
Yes. 200 foot of a church. I don't know if that was the only reason we denied it, though.
Well, it was automatic.
Yeah.
Yeah, there was nothing else listed.
So what are you doing differently than the other stores nearby? Have you gone in the other stores?
We have. We plan on getting a lot of products that are made and produced within the state of New York.
You gonna have a manager, or does anyone have experience in this business? Yeah. And everyone's going to keep their present job, so this is all going to be a second job for all of you? You guys must really like each other.
You're going to be seeing each other a lot.
All right, well, there's no protests and sales are spotty, but
There are increases.
what's in the air? Is this a standalone building or are you in a plaza?
If I may answer, this particular location it's a strip building with several retail stores. Across the street is a restaurant, and then there's some mechanic stations, and it's a residential area.
What else is in the plaza? What other stores?
There's an ice cream shop that's seasonal. There is a Mexican restaurant. There's
It's like, is there a big anchor store or anything? Is there a big anchor store like a supermarket or something, or? No.
there's a deli across the street.
Chinese restaurant is an anchor.
I guess we could say that, right?
Okay, go ahead. You guys.
All right, I'm good.
I'm going to vote to approve.
I'll vote to approve as well. Yonkers seems like it's exploding with condos and things like that. I don't know what's going on there, but there's definitely some construction, a lot of new places going up. I'm looking at, there's a couple of stores that have been opened within the past couple of years, but everybody's sales seem to be strong, increasing a little bit, except for one, but, so I'm going to vote to approve.
I'll vote to approve. Good luck.
Thank you very much. Have a wonderful afternoon.
Next item is 2105 Juicery 4 LLC.
Interesting.
Good afternoon, Thomas Cowan, the applicant, principals, Heather Tierney, and David Ochoa.
Is there any opposition here? That's surprising. We did just, I'm sorry, because I don't think you got this letter, because it just came in yesterday. We did get a letter from Assemblyman Lentil opposing the granting of this license, and maybe you can explain this, and I thought the community board would be here to explain it. There seems to have been a miscommunication throughout the entire process here with the community board? Okay.
I can address that and go through it. What I'd like to do is just distribute some photos, worth 1,000 words. I think this will be beneficial, save on words, just to get the sense of the scope and scale of the proposed operation. It is a vegetarian-style restaurant. The licensees have two in Manhattan, each number 2, one on each side and one in the West Village. The application speaks for itself. The ALJ's report was excellent. The ALJ.
I thought you would think that.
She covered it, was comprehensive, and at this point in time, I mean, the community board has done little more than just toss up a few points procedural as to why this application should not be heard and or approved. We did everything which is required of us. We sent the priority mailing to the community board. We have proof of delivery. That was in October 17. We weren't on the November agenda for the community board, which is normal. We waited at the same time on the agenda, so at the beginning of January, I did communicate directly with the community board as when we would be on the agenda. In my initial notice, I asked to inform when we would be on the agenda. And we would go back and forth. I sent them the proof. I sent them a copy of the original 30-day notice with an explanation. I asked a number of times to put this on the agenda, and not much would happen.
I'm sorry, can I ask you a question? Which one is actually the location in your application?
No, those are the two other locations they have.
This one? In the round corner?
One's the West Village, one's on 10 Main Street.
No, but he
Yeah,
wants to
I
know which
want
one is the
one
application.
That is in the application. This one? Okay.
Okay, so again, we do have a bonfire restaurant, but back to the chronology. It proceeded along. Their other two locations do have sidewalk cafes.
So let me just go back though. You re-notified them essentially in October via email asking when you were going to be on the agenda,
That was in January.
In January, but, and you still had not filed the application?
I hadn't filed the application.
Okay.
So we had notified them, we requested that they give copies, they didn't do the delivery. It's an accepted means of delivery, U.S. Postal. And again, they have to receive.
Well, at any rate, you re-notified them in January, so.
And there are actually a number of different means to go forward. As I said, there are two other locations have sidewalk cafes. They retained an architect for the sidewalk cafe application. Sidewalk cafe applications through consumer affairs take quite some time. So they notified community board number 1 regarding the sidewalk cafe application. It was noticed, there was a meeting, there was a hearing. The community board didn't want to entertain it. They wanted a copy of the liquor license application, which hadn't been submitted yet. We were still preparing it. If you wanted to be ahead of the curve, they know it could take upwards of 9 months for the sidewalk cafe. They were told that they would hear it, they withdrew it, and then I immediately filed the within application before we here today.
And still never ended up on the agenda?
Still haven't ended up on the agenda. They had ample notice. We were operational.
And who were you in contact with? Was it the committee, the liquor committee, or was it the?
The committee or the district office?
District office. Maria, I have the phone or something like that. So, I mean, all that was done. We filed a license application. We posted the notice in the window. And in fact, first I heard and they heard that the issues with the community board and opposition were days before the July 500-foot hearing. We received copies of some letters, and there was opposition, both written, letters submitted.
Look, I believe you. I just think that to have so many letters written in opposition, I wonder if it would be worth your while to go back to the community board just so that you can be considered a good neighbor, or you prefer not to do that?
No, I prefer not to do that because if you read the letters carefully, they're a generic place talking about late hours and noise.
That's not generic. Those are the concerns. I mean,
But the application specifically is a breakfast, lunch, and dinner. Presently, we're operating for breakfast and lunch. Our hours are 8 a.m. to 10 p.m. Background music, no outdoors cafe. So the ills and the adverse conditions of General Williamsburg, they don't exist in this application. There's a license with the authority in one location since 2013, 2015. They have a sterling record. There were allegations that we look at, go to the end around the way the community.
Well, that was my problem with what many of these letters is based on, and you've obviously documented everything you did, which makes you a good lawyer, and based on these letters, they're accusing you of like unethical conduct. Not unethical, but basically saying that you did try to do an end around, which, based on your documentation, is completely incorrect, which is what the ALJ found too. And I'm not gonna, I mean, I don't know how long we're supposed to make these people wait.
Exactly. We've been operational, but with a hamstrung operation with just breakfast and lunch. Again, fresh fruits and vegetables, it's their branding, they're all perishables.
Is there any, what was her name, Miss Bueno?
Marie
Bueno, did she ever acknowledge that she got all this notice?
No, but again, they.
Was there any explanation?
Yeah, there was a conversation, thank you very much, I have it.
No, was there any explanation about why they never put you on the agenda?
No, zero. And again, there are.
I mean, even the assemblyman is accusing you of, and I'm going to guess he doesn't have all the information, but he's even saying that you did an end around, and it's obviously not accurate.
The letters are very similar, it's just kind of a template boilerplate. That's that, but again.
No, and he's a very level-headed guy, so I'm guessing he got bad information.
So weird.
Are you?
They actually, we showed them that we submitted the application to be on the, what's it called, the agenda. And they said, well, you don't have a signature. You didn't get a signature required. We said,
We covered, that's all covered in the paperwork, but. No,
All right, so what is it that what are the hours here? You're going to do breakfast?
Yeah, it's breakfast. We're currently doing breakfast. It's breakfast. It's 8 a.m. to 10 p.m. daily. Presently, we're operating 8 AM to 4 PM because with
Right.
the license to serve beer, wine, it's just hampering. And with the perishables, the fresh fruits and vegetables, it's tough to order.
And just, is there any music whatsoever, background?
Simple background.
And then what's the hour, do you have outside, did you get that, or no?
No, they wouldn't entertain the application, but we'll come back in the future. Right now, it's to operate. We know we need to go back to consumer affairs. We know we have to go to community board number 1. And again, I just want to reiterate, I know your role here as members of the authority, but public interest, this one particularly screams, it's in the public interest. This is on Metropolitan Avenue. As we all know, the L line will be closing for 18 months.
What about the folding doors on Driggs and Metropolitan Ave? They said they want them closed. The Fillmore Place Historic District says that looks like 10 PM is okay with them, but the folding doors will be closed in the evenings and Sunday brunch. You want those open or not?
Well, I mean, I have that in their letter. I actually researched that organization.
Yeah.
It's an organization for the preservation of historic Italianate homes in Brooklyn. So they put that request in a letter. It was never conveyed to me. It was
Yeah.
conveyed to them.
Well, are you willing to agree to it? Because we're doing the work now.
Well, it depends on the weather. I mean, most of the time our clock is very windy, so it just depends on the weather.
Are you willing to close it by 10 PM and on Sundays?
So their hours of operation are 10 PM, 7 days a week. With French doors, they'll be open as needed depending on the weather.
All right, why don't we say you close the doors at, let's say, 8 in the evening, and you can have them for Sunday brunch.
I'll do 9.
Or 9 in the evening, and they said closed.
They said closed.
Period.
No, they said close in the evenings, which sundown, that would,
No, I mean, we will stipulate to closing French doors at 9 PM, the premises.
Okay.
It's operation at 10 PM.
And then, like he said, the brunch is fine, you can leave them open for that. And 8 to 11 PM hours.
Well, actually, we amended the application, it's 10 PM.
No, but I'm going to give you to 11 so nobody gets in trouble. You can shut at 10, you can shut at 7, I don't care. And I am going to ask that you, after we grant this, that you do meet with the community board and try to work something out with them. But it's not, you're going to get the license, so it's, as far as I'm concerned. But I don't know what went on here. It seems like somebody over there dropped the ball but I'm not going to make you wait a year. Well, you already waited a year. Another year. I'm not going to make you wait another year.
Yeah. And I'll, for the record, also say that a lot of the objections that the ALJ found to be unfounded, I concur as well.
All right, so do we all agree with the 11 PM background music and the French doors closing at 9?
yes. Do you have an electronic paging system at your other restaurants?
Lines, do you get lines?
Oh, right, see. Yeah, we building it right now through our PO system. So it's connected to our PO system. We're building it right now from Resi, which is a very well-known.
It's mostly like reservation-based, your business? Okay.
We do have it in Los Angeles right now, our locations, and then we bring it right now to, especially buildings a little more slow pace than Manhattan. We want people, and in winter, we want people to go and go back.
So you don't have lines outside, wait lines?
At the moment, no, because,
What do you expect? That's what she's concerned about.
There'll be street control, there'll be adequate street through a paging system.
Okay.
And just so reminders, sandwich boards are illegal.
Thank you.
Jonathan, we're all set then, right?
Yes.
Yeah. Jonathan, can you check that mic, please?
You're good, yep.
Thank you very much.
That's.
The next item is going to be,
Don't know why I shut them out. It's a nice round.
did you break our mic?
No.
Testing. It's on.
All right, next item is 2118, Inn at East Wind LLC.
It's weird.
This is a finding of fact, 2 charges, disorderly premise and insufficient security. I submitted a controversion. I'm confident you read it, and I feel the ALJ, he just flat out got it wrong. If you need a little refresher, there were 2 events taking place. There was an encounter in a lobby. Someone stepped on a bridesmaid's dress inadvertently, and a woman punched another woman. And all hell broke loose. Oh, it broke loose. I saw the video, I saw the tape, and it was really the definition of sudden and spontaneous. It was quite remarkable.
But it says here, none of the licensee security guards made any effort to intervene.
They would be unable. As I put in here, it wouldn't be prudent, it would be perilous. I mean, really, the blame goes to the volunteer firemen, and they were out of control.
Oh, these were firemen?
There were 2 things. There was a volunteer fireman installation dinner in one of the ballrooms. The hotel, I should say, the wedding reception was at a cottage. The guests came back after the wedding reception. They were going to their rooms. They were taking photos. They were milling about in the lobby. And then one of the women from the fireman installation dinner stepped in a bridesmaid's dress. There was a punch, and it was wild. To Commissioner Ford's point, they wouldn't cease. When the police arrived, they wouldn't stop. They would threaten with tasers, and they would erupt and erupt and erupt. You could have they actually had a small army trying to break it up, and they couldn't break it up. And to lay it at the feet of the licensee, who has an admirable record, I think I correct the record, it's for 16 years, not 20 years, and it was just that one-off event, and no amount of security could have prevented it. There was commentary, you should have a security booth with someone monitoring
What
cameras.
is this, a catering hall?
It's a hotel with catering, banquet rooms, 4 banquet rooms. And then on the grounds, they have a couple cottages for, particularly for wedding receptions. But to expect the chief of security to jump in, it's impossible. The police couldn't break it up. No one could break it up. And like I said...
Anybody get arrested?
Yeah, the 4 volunteer firemen. One of them was a sergeant or a captain. Yeah, they were arrested, and they were out of control. And the testimony of the police officer was, I got there, and he said he looked there and called for backup immediately. And the chief of security, he did the right thing. As soon as he heard it, which was mere seconds, he had the front desk call for police, call for backup, shut down the bar restaurant, and did his best with a couple of other to have them escorted, get patrons out of the east lobby. And again, the case law there, I cite the case law. This is a perfect example of sudden, spontaneous, and...
Well, I'll dismiss based on their history, and it does sound like it was a spontaneous incident.
Thank you very much.
I agree.
All set with that? Okay.
I'll dismiss as well. I've played a lot of weddings in my life, and I'm telling you, this is one for the books.
I'll show you the tape. No.
Next item is 2160, Talk House, Inc.
So your clients are open right now?
Which clients? This one, Talk House? No, Talk House is not. Talk House license expired at the end of September. There's an application pending. This was a violation for overcrowding for this summer for the prior licensee. If you read it...
So you're representing the new guys?
Yes.
Okay.
And again, obviously...
What new guys?
There's an application pending. So
it's the new guys? They're new guys? They're selling their business?
Yes.
They're selling to a different group of people?
Yes. And this
That's not the information I have, but okay.
Yeah, this took place
And
prior.
would you be surprised if I tell you that I was there over the weekend?
No, not at all.
Didn't know
And
they
it was
had
open?
They have temporary
They
licenses.
have a temporary permit.
Okay.
They have temporary permits. It's a recognized venue for decades. And in this instance, this is clearly a case of no good deed goes unpunished. They were having a fundraiser. Sirius Satellite Radio has an annual fundraiser at Stephen Talk House to raise monies for wounded warriors. And in this instance, from what I heard, they said that, some of the Sirius Satellite Radio people were sneaking in their friends and celebrities. They were overcrowded. We don't dispute it, looking to settle it and looking to get some kind of mitigation because, they were doing the right thing, and $2,000 fine it's steep.
Yeah, 200 people in there, and it's got a capacity, of 112, so almost double.
Yeah, I mean, I did those.
All right, I'll give you $1,000.
I mean, since, you've been open since 1988, right?
Yeah, yes, absolutely. And again, it was all for a good cause, and, you know, I'm not disputing the overcrowding, I'm just throwing in mitigating circumstances.
Yeah.
And then I don't know what Commissioner Fan's going to do, but with that, she can explain to us what she was doing there over the weekend.
Yeah. And you didn't invite us. 1,000.
Thank you.
I would go with 1,000, but
Thank you very much.
Next item, 2154, Minkato Restaurant, Inc.
I'll accept.
Did they get the permit?
They did, yeah. I checked with Mr. Amarato immediately following. Ultimately, the kitchen equipment was not operational. They shut down the kitchen, there's the non-bona fide with the food, but everything's been remedied, rectified, and the public assembly permit was reissued.
2154.
4,500 accept.
Accept across the board?
Yes, she didn't have the case.
4,500, it's okay.
Thank you for your time, attention, appreciate it.
Was the place overcrowded this weekend?
Next item is 2107, 511 Ninth Commercial LLC.
Say the number again, Tom?
2107.
I'm just getting my materials, I'm not back.
That we can fix later. Just wait till it goes through and then check it out.
Good afternoon. To open or to close? The roof.
That's the issue.
Is
Basically.
the community
we-
board here or no? No.
Sorry, what number is this?
2107. 2107. Okay, go ahead, I'm sorry.
Because I voted on this on the community board, I'm going to have to recuse myself.
So we appeared before the community board. When we originally went to the community board on this application, we had told them we wanted to put in the retractable roof, which we put in as part of the establishment. They told us that they did not want us to have the outdoor area open, but to come back to them after we established that we were good neighbors. We waited. We've been open and operating for 2 years. We haven't had any violations, any complaints of any kind.
They're saying that they told you not to do it. Or is that not what they're
No,
saying?
that is completely incorrect.
It says that according at the time, the BLP committee requested and the applicant agreed to the following stipulations regarding the second floor terrace. There will be no outdoor space or any retractable roof. Second,
Use of the retractable roof. They left that one word out of there. It was always going to be.
so he didn't
retractable.
put in the retractable roof? Or did he put the retractable roof in or was it there already?
They put it in. We told them we were putting it in, and we told them we were going to come back after we proved we were good neighbors. The applicant has several other places.
They're telling, their letter indicates that they told you not to put it in.
And I'm telling you that is completely incorrect.
Okay.
In fact, when we went there were members of the committee who remembered it and talked about how, well, when they came here, they told us they were doing the retractable roof and about coming back. It was, some of them remembered they said you could come back. Some of them remembered maybe we didn't say you could come back. We usually don't do that. But we went back and forth on the issue. Regardless, 2 years later, we went back about opening up the roof. In fact, we went back opening up the roof. We had originally asked for the hours that are in this application, but even in an attempt to work with the community board, we said we would scale back the hours and there would be no music playing when we had the roof open, and the community board still didn't want to entertain this application. If you know this building or where it is, 90% of that back roof opens up right towards the entranceway to the Lincoln Tunnel. So
Go ahead.
So that noise is going either right out towards the Lincoln Tunnel and the entry ramps to the Lincoln Tunnel, which is more noise than you could ever imagine. And behind us is our landlord, the hotel, who, believe me, doesn't want any noise or disturbance for their hotel guests.
Okay.
Looks like the buildings that are higher than you are across the street on Ninth.
Excuse me?
Looks like buildings that are as high as this building are across the street. on
What
Ninth.
floor across the street and not where the noise is going because our building is up.
What floor,
Back of the building.
Terrace is in the back.
what floor?
It's on like the second floor mezzanine, it's in the back, and 90% of this
So we can't even see it.
floor is outdoor
Come,
terrace.
point this out. Yeah, just showing you.
So here are your ramps and everything for everything tunnel. We're on the back side here. You can't see it. It's. There is, right there. It's right there. There's only two buildings, two brownstones here and two brownstones there. The rest of it is where buses park, Lincoln Tunnel and Hudson River.
This is a wall right here, right?
That's usual. Yeah, the tenants of the building across the street on Ninth Avenue, but we're in the back of the building.
And these are all hotel?
Yeah, it's all.
So who's complaining about this?
Well, this is the point we raised that night, that we didn't understand who was complaining because.
Mr. Flint, can you get back to the,
We didn't understand who was actually complaining or how anybody could hear the noise when it's going right back towards the tunnel. Like I said, 90% of it off, there's maybe a 5% sliver off to the right where that one building is. And then maybe if you really went this way on an extreme angle, there might be another 5%. But 90% of this goes right back to where you see the tunnel there.
What about the brownstone? People live there.
That's that 5% sliver that was right there. But I don't even.
To the right.
Right.
And two to the left.
And I don't even know how you could hear it with all that traffic on the ramp that is going into that tunnel. Plus, we agreed that there would be no music. It would only be the people who were at the space, they're talking or whatever else in the open roof area. I mean, in theory, if we had a sidewalk cafe out front, these hours would be no problem. This is up 2 floors with a huge hotel you can see in front of it, so none of the noise is going towards the residents across the way, and the only way this noise is going is back towards the tunnel.
And you did an acoustic thing? Test, is that correct?
Yeah, we did the little sound report we gave to the community board, yep. Sound engineers said the
So
same
who's
thing.
saying that they can hear and feel vibrations from the noise in their apartments?
This is, somebody came.
We don't know?
No, there was a resident who came and said that they felt it. We asked where they were, they said they were a building, what was it, down the block. It's impossible.
Right. They were not even near us.
And I don't even know how they could do it when we're not, it's been closed the entire time, and that's never been a question, so I don't know.
And I used to take those buses, and
Yeah,
they're lined up that ramp. I mean, that's one of the loudest, it's got to be one of the loudest areas in New York City. I don't even know why you'd want the roof open.
Well, you know what it is?
It's kind of beautiful for a New York City layout because the Hudson River is right behind it. It's kind of, and also you have to understand that most of this premise is all terrace. We have a small spot downstairs, about 500 square feet, and then the terrace is about 1,800 square feet. So if we don't get this open, we basically go out of business.
Yeah. And what the main point of this is that, and I can tell you, when we went to the community board originally, this was our intention, and we drew it off the table. In fact, the stipulation that you see in the file was the one we entered into with them. We pulled it off the table because they wanted us to show that we're good neighbors. The applicant has several other places in the city, all with good record. This place has had 0 violations the entire time they're open.
What is this building? Is it a hotel or what?
It's that we're in, yes, it's a hotel. So there's rooms there, there's rooms to the L on the right-hand side.
So the first people who would be annoyed would be guests.
Would be the guests of the
Should be
hotel,
real
our
stupid of
landlord.
you.
Yes. Completely, and none of the guests or the hotel have a problem with the operation.
All right. If the chairman doesn't have any other
I
questions.
don't, no, go ahead.
I'll vote to approve, but I'm gonna keep it at midnight, 7 nights a week. Let's start there, okay?
Yeah, I'll agree with that.
Thank you very much.
I just don't know what the hell is going
All
on.
right, the next item is 2113, the Bronx Sports Emporium LTD.
We need to wait for Commissioner Fan to come back?
Yeah, we need her back.
Okay.
What number is that, Tom?
It's going to be 2113.
Good afternoon, Chairman Brown. Hi.
Signed in for her?
Yeah.
Yeah.
It's loud to begin with, isn't it? I'm sorry, go ahead.
No, go ahead.
What number are we?
This is 2113.
Councilman Bond.
Go ahead.
What are we talking?
I'm here for, good afternoon, members of the authority, Councilor Riano. My name's Aurelia Tavares. I'm here for the licensee, Yarton Garcia, the owner of Bronx Sports Emporium. We surrendered our license, and this is for cancellation, but it's with a heavy heart that I present this licensee before the members of the authority for cancellation. He wanted to make a final statement because we're going to be back because it was a mishap that this happened. He just wanted a moment to explain himself because he doesn't want to
Sure.
present this at this way.
Good afternoon. First and foremost, my apologies for the events that have happened in the past few years. I purchased this business about 7 years ago, and I purchased the corporation from the previous owners, which at this moment right now was a huge mistake in my part. I hired an attorney. I hired my accountant, and supposedly they did their due diligence in seeing that it was a bulk sale and everything was in order. It turns out that the previous owners were filing their taxes in Westchester instead of in the city, in New York City. And somehow, when I purchased the business, that, they told me I had a good guy letter, and I started paying my taxes. I started running the business properly as I thought, and it turns out that the corporation was dissolved for taxes that were not paid by the previous owners to the city. From what I understand, it was a small amount, but at this point, from what I just found out a few months ago now is that my corporation was dissolved since 2016, and I was not aware of that. I've been running this business for the past 7 years with my wife at the time. She passed away from cancer a few years ago. So it's been pretty tough. I hired a manager to run my business about two and a half years ago after that incident happened with my wife passing away. And unfortunately, my first wife passed away a month after that. So I've been taking care of my children, and I hired a manager, and I did the best I could at that time. And, my business kind of went upside down. My manager was not doing the right thing as far as, paying workman's comp and doing all of this. And it was not even a monetary issue because the business is viable. I've been in this neighborhood for 7 years. I own the building. The community board is literally across the street from me. So that's not an easy business to run, especially when they're right across the street from you. So I have a good rapport with them. I've been a part of the community. I retired as a telephone man. I worked for the phone company for 20 years. And I lived in the neighborhood. I owned the building there, and that's my place of business. That's how I feed my family, and unfortunately, all of this has happened.
I feel like the rug has been, pulled underneath my feet at this point. And, it's a business that I employed a lot of people. Everybody lost their jobs, and I've lost my, my means of sustaining myself. So at this point, I just want to apologize for all of these things. I have to surrender my liquor license, which, it's not an easy thing to do. But at this point, I would like to have an opportunity, if I may, to reapply and go forward. And hopefully, I could sustain the business better than I have prior to that.
Okay, thank you.
Thank
Good
you.
luck.
Thank you.
Well, and we'll accept the cancellation.
Commissioner
Accept.
Fan?
Yep.
And Commissioner
Thank
Ford,
you,
okay.
members of the authority.
Next item I have is 2138. Mr. Flynn, it's Sino US Entertainment, Inc. Mr. Flynn has to get downstairs, so.
Sure.
This is an offer of compromise.
Well, accept.
Except,
500 accept.
Thank you very much. Have a very nice day.
See ya.
The next item I have is 2086, and there's a related one. Oh, no, it's a different license, different name.
86 and 87.
2086 is Birdie Restaurant and Lounge Corp.
And
Well,
87.
2087 is a different serial number. Oh, it's for the old place, yeah. So it's 2087 is the license, the removal for the same place. It's under a different serial number because the disciplinary is under the old one, the removal is under the new serial number.
The disciplinaries on the.
All right, so
let's go back to license.
2086, I'll grant reconsideration just to accept the money. And then 2087, I'll grant reconsideration to reopen the removal.
Thank you, members of the authority.
Agreed.
Commissioner Ford?
Yes.
Yep.
I just have one more.
What is it?
It's,
The next item, let me, all right? 2147, Ulitzi Corporation.
Sorry, the.
2127?
2147.
I'll accept.
Okay.
Accept.
2,500? We're good?
Yes.
Great.
I'll accept.
Next item is 2081, 950 Convenience, Inc.
I'm sorry, what number is that?
2081, part of
It's 2081, 950 Convenience, Inc.
Good afternoon. My name is Chapatap Kang. I'm here on behalf of my aunt. She had accepted the no contest plea and faxed it over, but I think she's in default.
Where is she now?
She was sick. She wasn't able to make it, so I came. She asked me if I could come for her.
So this is the second time, sale to minor. I had 6,000.
6,000.
6,000.
Yep.
Thank you.
6,000.
Thank you.
And last item I have signed in is 2166, Brown Note LLC.
Good afternoon, members of the board. Alexander Victor, David F. Hutcher, and Citron. I'm here with Monica Hudgens and Andrew Isley. They're the two principals. They're the two principals of the applicant. I don't know how much you remember of this application, but we were here back in July. This is an application for premises that Ms. Hudgens and Mr. Isley operate as a acoustical engineering showroom for the products that they create. They are both well known in their field as audio engineers, and they have a sound system that they've created, that they showcase, that they sell, that they rent in connection with their business of curating performance art-based events. And it's always been their intent to run a bar in conjunction with this operation. We've been trying to present this matter to the community board for about 10 months. And when we came before you in July, it's not because we were avoiding the community board, but they wouldn't hear us because we didn't have certain documents that they said they required to be put on their agenda. At that hearing, Chairman Bradley, you alerted us that you received a letter from the police department that talked about 22 complaints. We talked about those. I said none of them have ever been sustained to my knowledge. It turns out they haven't, but because there were those complaints, you wanted to give the community board an opportunity to hear this matter. You directed us to contact them and tell them that they should hear this matter, or try again to hear this matter, and to work with the police department to see where they stand. What I'm very happy to sort of report back today is there's been a lot of progress, a lot of good progress. The first stop was with the police department. My clients and their head of security met with the community affairs officer, Officer Gomez. My client talked to them about all of the work they've done to improve safety along the block. They've increased lighting. They've done additional sound attenuation measures. They will have security there every time there is an event that's more of a nightlife event. And the police officer confirmed that there's been no action, police enforcement or action on this place since 2017 or in 2018. And they took back their letter saying, their former letter was, we do not recommend approval of a liquor license. The new letter that they sent to you, I submitted it in one of my emails to you, said we do not foresee any issues with getting a liquor license here. We then went to the community board and reported all this progress. There were 3 individuals that came out in opposition. I don't know that you want to get into the details of it, but those 3 individuals also had prior personal and business dealings with my clients that sort of tainted their view of this application. Putting that aside, we accepted that there may be concerns about their operation coexisting in the community. So we worked with the committee and we said we'll do additional sound attenuation measures. We will happily do a sound test with DEP and the local precinct and with members of the community board. That was done 5 or 7 days afterward. DEP came out, Officer Gomez was there, 2 members from the community board, and testing was done from outside the block. Everything checked out and there was no problem. Testing was then done from the garage adjacent to their premises where someone is alleged to live. We don't know if they're allowed to live there or not, but assuming they do, testing was done there. The DEP...
What do you mean you don't know if they're allowed? We
don't know if the zoning or if the building certificate of occupancy permits legal residence. Putting that aside, the DEP agent said that the sound levels checked out, but please reduce them. Would you agree to reduce them? My client said yes. They had a great meeting with the committee. They had a great result from their sound test. The committee voted unanimously to approve their application, the only conditions being to have the sound test and agree to those limits. We offered to have security, which we'll offer to do, and to close at midnight on Sunday. The community board, full board, did not follow that recommendation. I was not at that full board. My clients can tell you more about it, but we can only surmise that one of the individuals that allegedly lives 50 or 75 feet away, who is known by my clients to be friends with a board member, did something in advance of that full board hearing to turn the tables against my client. They did not have a fair opportunity to present.
Well, I mean, they voted against it. I'm not going to get into what
voted
went on.
against it. There were people
At the end of the
support.
day, it's not a 500-foot case. So.
It is not a 500-foot case.
I just wanted them to meet with you to at least voice their concerns, which they obviously had the opportunity to do.
And we are assuming their concerns are legitimate and accurate.
And then the
taking
police
steps.
department was a big deal to me, too, which is now cleared up.
Hey, explain to me what this place is again.
I'll let them continue it.
Yeah.
During the application process, the examiner asked for us to clarify, so I did a letter. Okay. And they can tell you what they intend to do with it after as far as educational programming, but essentially it is a showroom where they demonstrate this sound system that they've developed. They then use that sound system to they rent it out, they sell it, they create new sound systems for other people. And the best way to showcase it is to have an event.
Let them talk.
Sorry.
What is it?
When Andy and I
And
met in...
a microphone,
Oh, I'm
please.
sorry. When Andrew, my partner, and I met in 2009, we were both proponents of a bass culture music and sound system culture. In New York City, there were very few venues that allowed the music to be felt full frequency. Club Love was where Andy was an engineer to 2010 when they went under. There was an event called Dub War that we decided to enable. That closed when Club Love closed, but we decided we wanted to build the right environment for the music that we support to be appreciated in. And this is not just hearing it, it's feeling it. So our venue, the Brown Note, which is a double entendre play on words of the Blue Note and the mythical urban legend of the Brown Note. But the idea is that in our space, you're not there just listening to the music, you actually feel it full body from head to toe. We have an art installation that's built into the space. It's a full immersion system. It does not have to run loud for you to feel it. And we have transducers built into the art installation that actually channel the bass upwards so that you feel it and it doesn't bother the outside. Our DEP compliance is straight on. We have the exact levels that we need to be in full compliance, and we even agreed to bring it down lower than that.
DEP is coming back in about 2 or 3 weeks after the license is issued when there is an event, because the testing that they did was an empty space. So they're going to do it when there's actually people there too. And if the levels need to be readjusted, they'll be readjusted.
How many people fit in this place?
We went for a 290 occupancy.
And what are your hours?
Like the hours that we agreed to with the committee, which were until 4 a.m. except on Sundays that close at midnight. But those are the hours that the community board here imposes on every establishment. And in their resolution, they attached, the 5 or 6 other places that they did approve with those hours.
And they know it's all about the base.
They know everything that you know now.
Council, have you seen the certificate of occupancy?
I have.
And what does it say?
It says eating and drinking for $290, no dancing.
Right, so is there dancing happening at this place?
No, in fact, we encourage people to stand on, because the problem is if you move when you're on the platforms, which covers the entire main floor of the installation, then you don't feel it. So you have to have your feet stationary. We have people that lay down on it. We do movement classes. We do seminars where people sit on it, workshops where other producers explain how to make the music while people are actually feeling those frequencies, and they're not loud. It's about feeling it within that space.
Sound healing workshops,
He's
yoga
my engineer.
workshops.
The method of operation here says there will be dancing by patrons and performers. Is that not accurate now?
What I
Not
recall from
patrons.
the application is there would be no dancing unless it's permitted on the certificate of occupancy, which it's not.
There's a small stage to the left
Oh,
of
you
the
didn't have the
installation where
certificate of
people
occupancy
can-
at the time.
Performers can dance.
Okay.
But it's only
They had
artistic
a tent
performers.
that said the same thing. I mean, your community knows you. The community board voted to recommend for us to deny.
But on the basis that they felt that a place that was 75 feet away from a residence was too close to be licensed. If that's the case, no place in Brooklyn, Manhattan, Queens.
I can't really judge what was going through their minds, but if a full board voted against it,
It was 26 of the 40 board.
Everybody on their liquor license committee voted for it.
All right.
yeah, there are 4 people. I'm going to vote to deny.
Okay. Since this isn't a 500-foot case, I don't see any good cause myself to deny it. So, and you did go back to the community board and straightened out the issues with the police department, which were my bigger concerns.
We're also going to the adjacent community boards to talk with them too.
Okay.
And we intend to continue working with our community board, even though the last meeting was extremely traumatic for us. We intend to continue fully working with them in the future. We've already got.
Well, then I would encourage you to do that. So I'm going to vote to approve with the hours that the committee, what were they?
12 o'clock close on Sunday, 4 a.m. every other day.
Okay. Those hours. And no dancing.
I'll approve as well on those terms. No dancing, that's just odd to me.
It does, but when you experience it,
certificate of
I can
occupancy
show you
is no
pictures of
dancing.
people laying down on the platforms, people stand, because it's more about appreciating the full frequencies of the music and not just hearing it. You want to actually feel it in your body. That's what
There
it's
are always police reports about rave parties and all of that.
It's not us, and we proved that wasn't us. The police agreed that that was not us. That's
No,
Spectrum. That's the legal
this
spot around
officer
the
was
corner.
pretty active in objecting to you, so the fact that he doesn't anymore means that
We work
he's
closely
gotten
with them
new
from
information.
May to August to make sure that every
Commissioner,
event comes under
Commissioner
compliance.
Ford,
I'm a bass player,
Oh, wow.
and I play all the time. and my bass cabinets, so they don't annoy anyone else. They're very small, 5-inch speakers, just 2 of them, and I stand on them all night.
We can show you our entire range of.
If you
Well,
just
I'm
let
saying,
them,
I get it, what you're trying to do. It can be done without annoying people, so, I'm going to approve. I would anyway. All right.
I don't have anything else signed in. So are you here for something?
He was with us.
All right. Are you ready to move forward?
Yes.
Hang on 1 second here.
You ready?
Yep.
On 2078, Mr. Palillo had contacted me. He wants it held over. The full community board has not met yet. So
Till when?
So it's going to be 11/6.
You said 2078?
Yes.
2078, yep.
Okay, all right.
2080.
Cancel for the record.
Cancel for the record.
Cancel for the record.
2083.
6,000.
Wait, what?
2083.
Oh, I'm on 2080. I'm sorry, you're right.
The recon.
2083?
Oh, yeah.
Did we do 2080?
Yeah, you just said cancellation.
Carnival
Oh, no, I
Blues.
did another one, hold on. 20, what happened to 2081? Oh, we did that, okay. Yeah, I'll take the,
So
I'll take
we're on
the,
the same page.
I'll take the,
2080, we're all canceled, right?
yes.
Right. Now 2083.
I'll take the 4,000.
There's no 2083?
It's a recon to accept $4,000, right?
No.
Vulcan bond.
Where's the 4?
Oh, I see what I did, okay.
So 2080 is canceled.
No, this is 2083. I would grant reconsideration. I realize that the crime was pretty serious, but I don't know what this guy's gonna do. And,
Grant
I was on not granting consideration.
which I could live with too. so.
Yeah, I was gonna deny reconsideration.
Okay. 2085.
Accept.
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 2089.
I'm at 5,000.
I had 3,500. Sale, oh, wait a minute, sale to minor, failure to display license.
What'd you have?
I had 3,500.
And you had 5,000?
Yeah.
It's a little, because the failure to display license, we can only bang them for 100?
No, that's,
No. But we, I mean.
Or 250, what's the max?
that's,
on it?
there's 10,000.
Oh, there is a 10? All right, 5,000.
5,000.
5,000 it is.
What's the other one? Oh, the pregnancy one is?
The 2 warning signs.
Okay.
2094.
I'm at 25,000 or cancel.
Can I see that? I don't
Do
know
you,
why I don't
do you
have
want
these
to come,
numbers.
you want to
Oh, I got
consider,
it, forget it.
29.
you
Because
want to
there are
consider,
3 cases here
you want to consider 94, 95,
and 99.
and 99 together for purposes of
Yes.
penalty?
That's why I was wondering why you were so high. 10,
94.
7.
There are 16 charges.
Yeah, I'll go 25. I was at 21, but 25,000.
For
I
all
don't care.
3
how-
cases?
break them up equally.
Well, I was just going to combine them and say that it's.
Or whatever you do, it's fine.
25,000.
Because I don't think 16 goes into 25 equally. And
Of course it does.
Vote for the record.
Down to the penny. Now, let's go. Come on, I got to catch a train.
2096.
Revoke for the record.
Revoke for the record.
Revoke for record.
2097.
Accept.
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 2100 and 2101.
Accept.
Accept.
2103.
Deny, I guess, if they didn't show up, right?
It's not required for them to show.
Oh, it's not?
recommended.
And there was no proposed, no protest.
It's okay with me.
Yeah, I'm
Unless
fine.
we
I'll accept.
approve.
I'll approve.
Thank you for the new numbers, Jackie.
23, approve.
So all 3 approved, huh?
All 3 approved.
Oh, the removal, we all
Yeah,
approved
I
it.
know, I got that. I thought you meant like 3 applications. 2108.
Accept.
Accept, yeah, I'll recon to accept the check.
Yes.
Accept.
2109.
What is this? Deny. unless we have the documents.
What is this one?
This is
This is the one where we
back
don't
9.
have the documents.
Oh, so here's, go ahead, Jack, you explain it.
I don't even know if I want to go that far back to explain it, but I thought you were asking about the documents. I'm just going to indicate to the best of my recollection, we have everything we need.
We have everything we need?
Well, what happened was that the Senator Griffo called our office to see if we would give them a second chance. His office did, I shouldn't say he did. Give them a second chance to provide us with all the documents, which is why I granted it to come to the full board and indicated that as long as they get the documents to us before today, we would do that.
Okay, if we have the documents, then I'm okay with it.
So back to licensing?
Return to licensing.
Yes, return to license.
Okay. 2110,
Accept.
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 2111,
I'm at 5,000.
Disorderly premises, but by the security guard who was unauthorized, right?
Yeah, why didn't, so can I add a failure to conform charge here too?
well, you'd have to amend the pleading and then send it back.
All right, so I'll just go 5,000 because they're guilty of both of those
Yep,
things.
5,000.
2112,
Accept.
Accept.
1,500, accept.
2114,
Cancel for the
Cancel.
record.
Cancel for the record.
Yep.
agree with that?
Cancel for the record, yes.
2116,
Sustain 1, 2, 3, and 4, cancel and bond.
Cancel and bond.
Cancel and bond.
2117,
Accept.
I don't know why we would take anything here, though. It's the second time he did this, isn't it?
Still waiting on certificate of disposition, too.
All right, I'll accept.
I'll issue it then.
3,000, accept.
2121,
I'll accept.
Second
Accept.
time, 6,000, yep.
2122,
Accept.
Accept.
Accept, 6,000.
2123,
Accept.
7,500, accept.
Accept.
2124 and 25.
Counter 20,000 in 30 days.
20,000, that's what I had.
Yep.
And a
And
30,
a 30-day suspension.
Yep.
all right,
20 and 30, yes.
2128,
Counter 10,000. You don't get a discount for getting caught twice.
10,000.
Counter at 10, yep.
2133,
Accept.
2,500,
Accept.
accept.
2134,
Accept.
6,000, accept.
2135,
Accept.
Accept.
2136,
Accept.
750, accept.
Accept.
2137,
Only 20 minutes after midnight, so.
Accept.
37, 2,500, accept.
Accept.
2139,
Accept.
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 2140,
Accept.
1,500, accept.
Accept.
2141,
Accept.
3,500, accept.
Accept.
2142,
Accept.
42, 500, accept.
Accept.
2143,
I would counter at 5,000 here. I realize that she may not be able to get the witnesses, but this was crack.
5,000.
Sold by the bouncer.
Yep,
okay,
5,000.
2144,
Accept.
Accept.
you all go with that? 21,
Yeah, 1,500, accept. I had some questions, but I'll let it go.
2145,
Accept.
2,000,
Accept.
accept. Yep.
2146,
I had counter at 5,000 here.
Can even go higher than that if you want.
you want to,
The combination of 21, 46, and 48.
Oh, same place, yeah, isn't it?
I
Yeah.
was at 8,000 for the two.
So we have to counter both, Tom, or
you can do each separately,
All
or
right.
you can combine them for a
combine
counter.
them 8,000 counter offer?
8,000 counter.
8 for both. Okay. 2149,
Accept.
Accept.
1,000 accept.
2150.
Accept.
Accept.
Why would she not stay for this?
3,500 accept.
She just is.
2151.
Accept.
Accept.
No history, $1,000.
2152.
Accept.
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 2153.
I'll take the offer. And isn't this canceled
I
already?
am confused. This is canceled in 2018, right?
19. It just got canceled. I think it was a failure to pay.
Yeah.
Oh, I see.
Well, so we'll take the 6,000. It'll get canceled anyway.
Yeah.
6,000.
Okay, 6,000.
2155.
Accept.
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 2156.
Accept.
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 2157.
Accept.
Accept.
4,500 accept.
2158.
Second time.
500. Oh, is it the second? Yeah, is that what it is?
Yep.
I'm at 3,000.
Time.
Is it, but don't we have a delegation on what this is a second time?
I don't think for a second time.
No.
I don't know.
You want,
I mean, if you're gonna give something, I would give something small.
yeah, 500. That's what I had. What do you have?
500. I had
500 's
3,000, but it's okay.
2159.
Accept.
Accept.
Cancel and bond.
Yep. 2161.
What's,
Deny.
I'm
Or
still
withdrawn.
talking with Mr. Levy. You,
Hold over.
Last meeting, you asked me to have a conversation with
yeah,
him.
yes.
So we're just finishing that up. So I'm requesting it be put over for the next board meeting.
Does he need to have another one? Didn't he understand what we were saying?
It may be resolved in between, so.
Oh, okay.
Okay,
To 11.6.
yes.
2168.
These people, I know. But
21,
these people asked to hold over and then they didn't show up?
Yep.
I guess it's accept, whatever.
Wait, what did we on? 2068
2168.
68?
or 69?
2168.
Oh, I see. Okay,
Bourbon
yeah,
Street.
I'll accept then. They didn't ask to hold this one over, right?
No.
All right.
3,500 accept, yes.
2169.
I met with them last week and went over compliance
Okay.
reports.
All set.
This is supposed to go back one more time.
Yep.
You still want that coming back and?
No, no. No, it doesn't need to come back. Chris can just report
I'll
to
meet
us
with them.
when he meets with him the third time.
Yep.
We're all good with that?
All good,
Yeah.
yes.
Same with 2170 and 71?
Yep.
Yes,
Yes.
thank
Okay.
you.
2175.
Cancel for the record.
2176.
Cancel and bond.
Cancel and bond.
Cancel and bond.
2177.
Withdraw charge 2. Is this surrendered?
Yep.
Cancel and bond.
Cancel and bond.
Cancel and bond.
2179.
Accept.
Accept.
5,000 accept.
2180.
Accept.
Accept.
Second time in 8 months. 2180 is second time in 8 months, disorderly premises.
What do you want to do? I think this is a difficult evidentiary case.
I was going at 1,500. But if you want to take the 5, whatever.
Well, the only reason I don't think that we have witnesses,
All right,
am I wrong in that, Chris?
As far as I can, no.
all right, 500.
500?
Yep.
2181 and 82.
Accept.
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 I had nothing else signed in. Chairman, do you have anything?
No, but what's the, oh, I'm sorry, okay. What happened to 2107? Oh, like, we did, yeah,
You
you,
took
yeah.
care of it.
That's what I was gonna
All right.
ask you, all right.